Good morning, everybody. I see Mr. Holden is present for the state. Ms. Mitchell is present for the state. Mr. Moore is present for the applicant. And here comes Mr. Mayor. Mr. Coe, I know you are here for
Mr. Cargill.
Mr. Cargill. I'm sorry. Thank you.
Yes, Your Honor.
And I understood you had another hearing at 9, and I sent an email, although it didn't get, yes.
I'm good, Judge. I've got it taken care of.
Ah, all right. Okay, very good. Is anyone expecting a participant named Christy that will be appearing by an iPhone?
That's Mark Cargill, Your Honor.
All right. I was afraid it was my phone acting up. We've had a lot of difficulty getting on YouTube this morning, and I didn't want to admit myself, so I'll admit Mr. Cargill. All right. Then this is cause number 32004-A, ex parte Richard Gross. Counsel for the applicant is present. Counsel for the state is present. The court reporter is present recording the proceedings. Just by way of review, since our last hearing, Judge Charles issued a new order assigning me to this case as the senior judge of the 114th District Court. In the interim, I had made a ruling on the motion to quash the subpoena. And so having received that new order, I adopt the order that I made during that interim period for all purposes. I'm not sure the second order was necessary. Nobody else did either. So we just said, well, why not? Better safe than sorry. All right. The applicant has amended its application. Mr. Mayor and Mr. Moore, I'm assuming you're abandoning by amendment any other changes, right?
That is correct, Judge. We are only proceeding on the grounds set forth in the amended application.
All right. And we are missing Mr. Gross.
That's right. I was just about to say, I think we need to get him on.
We talked to, well, I say we, Ms. Singletary very ably talked to TDC yesterday about his appearance. So we'll just wait a few minutes before we get going anymore before he appears.
Great.
I will let you know we are on YouTube on my YouTube channel because there was a great deal of difficulty signing on to either the 3rd or the 87th. Ms. Singletary is putting a notice on the website that this will be seen on the Judge Kennedy YouTube channel. And if you have anybody that you know is watching, any family members or anyone interested in this hearing, please take this time while we're waiting on Mr. Gross to let them know that they can watch on the Judge Kennedy channel. By searching Judge Kennedy.
Yeah, we received your email shortly before we started, and we were able to convey that information to relevant actors or participants in this case. So
okay, so that's where we are. I'm sure Ms. Singletary has her account on, and I'm sure she is hearing us talk about Mr. Gross not being here. And so, well, there he is. She has ably gotten him on, so very good. Thank you, Ms. Singletary. Good morning. Mr. Gross, good morning. How are you? Mr. Gross, can you hear me okay? You're going to have to unmute yourself on your screen. Thank you very much. Are you okay this morning?
Yes, ma'am.
Okay, great. I see you have on a mask and you pulled it down to speak. I don't know who else is in the room with you, and if you need the mask for protection or if they need the mask for protection, you're welcome to keep it on or do whatever the rules are there at the WIN unit. We were able to hear you when you pulled your mask down. Looks like you've gotten some instructions and it's okay to pull your mask down. Is that right?
Yes, ma'am.
Okay, great. All right. Well, I started without you a minute ago. I'm going to go back over the things that I talked about. Some of them were extremely inconsequential. This is cause number 32004-A, ex parte Richard Gross. Counsel for the applicant, counsel for the state are present. Mr. Gross is also present. Everyone is appearing by Zoom, and this Zoom is broadcast to this court's YouTube channel at Judge Kennedy on YouTube. I did note earlier, Mr. Gross, that you had filed an original application some time ago. And since our last hearing, Mr. Mayor and Mr. Moore had amended your application to drop some grounds and add some grounds for relief. And the ones that they have dropped are dropped. And we're not going to consider them today, and it won't be in the court's findings of fact and conclusions of law. You understand that?
Yes, ma'am.
Okay, great. All right. Is the applicant ready to proceed this morning?
We are, Your Honor.
Is the state ready to proceed?
Yes, Your Honor.
All right. Thank you, Mr. Holden. All right, then, do you want to make any sort of opening statement, Mr. Mayor, or do you want to proceed with calling witnesses?
Judge, I don't think an opening statement is necessary. Before we do call the witness, though, just as a housekeeping matter, I think we'd like to formally offer and have admitted into evidence the exhibits that were attached to the original application for writ of habeas corpus. These are actually in the clerk's record, but I want to make sure that the court first takes judicial notice of everything that's in the clerk's file, and just out of an abundance of caution, actually accept into evidence the 64 exhibits that we attached and that I'll be referencing throughout the actual evidentiary portion of this hearing.
All right, then, is there any objection on behalf of the state to exhibits 1 through, was it 64?
Let me just make sure of that. I believe it is.
I have them right here. I think the last one is 64. They're not in order, though.
Okay.
I am trying to find these exhibits to look through them again and see exactly. I don't know that they're all necessarily admissible.
All right.
I'm actually not finding, looking at the court's file, a copy of the exhibit scanned in that you're proposing.
I don't know. They were sent to me in digital format by the district clerk.
And here's what I have, and I'll state this, and hopefully this will help everyone on the same page. So we have we have a 4-volume original clerk's record in this case. And beginning on the first volume of the clerk's record, that includes the original application for writ of habeas corpus. And that is followed by a beginning at page 48 of the PDF file is the bound exhibit list for volume 1. That shows the list of the exhibits contained within volume 1. All of those exhibits are then included in clerk's record 2 out of 4. 2 out of 4, I believe, has exhibits. Looks like it has exhibits 1 through 36. And then the clerk's record volume 3 has exhibits has exhibits 37 through 64.
Okay, she transmitted them to me electronically, and they're in very different batches from that.
Okay.
But they are all individually marked. I will say, for your benefit, Mr. Holden, for making an objection, the lion's share of the exhibits were appellate briefs and appellate opinions related to issue number 1 or ground number 4.
Okay. Well, I'm not seeing them, but purposes of the record, we're going to record no objection, Your Honor.
All right, then exhibits. Have you decided it is 64, Mr. Mayor?
No, Your Honor. I just realized we also have there's a third volume. There's a third volume of exhibits that's contained within clerk's record 3 out of 4 that has exhibits 65, which is Mr. Cargill's fee voucher. Exhibit number 66, which is Mr. Cargill's fee voucher for the appeal. Exhibit number 67, which is the certified copy of the trial proceedings. And then we are going to withdraw, it's in the clerk's record, but it's exhibit number 68 is as Mr. Gross's MHMR records. They were submitted under seal, and I don't believe they were included in courts. Let me double check.
Judge, I can clear that up. We actually did not submit them. The plan was to submit them under seal, and I reserved those 2 numbers for that purpose, but we never transmitted those forward.
And so you're offering into evidence what numbers, Mr. Mayor?
Yes, it's going to be 60.
Oh, let's start at the beginning. 1 through
67. 1 through 67.
And there's no objection to those for purposes of this hearing, Mr. Holden?
Purposes of this hearing, no, Your Honor.
All right, then for purposes of this hearing, applicants exhibits 1 through and including 67 are admitted into evidence. And so now, Mr. Mayor, back to my question. Did you want to make an opening statement, or do you want to just call witnesses?
Let's just call witnesses. I'm going to go ahead and call Mr. Cargill to testify.
All right, Mr. Cargill, pursuant to the Supreme Court's continuing orders to permit me to swear you electronically over this media, would you please raise your right hand and let me administer the oath? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. Please state your name.
Mark Cargill.
Thank you, Mr. Cargill. Mr. Mayor?
Thank you, Your Honor.
Judge, before Mr. Mayor starts, can we just have on the record that Mr. Gross is waiving any attorney-client privilege that he may possess regarding Mr. Cargill testifying today before the court?
Yes, and thank you for mentioning that, Mr. Coe. I actually intended to address that myself. Mr. Gross, I just need you to understand, and I'm sure your lawyers have explained this to you, that ordinarily anything you tell your lawyer is something that they cannot divulge. They cannot testify about it. They can't talk about it. They can't tell anybody else about it. However, when you file this application for writ of habeas corpus complaining of your lawyer's conduct, you waive that privilege. and your lawyer can testify about anything you told him. Do you understand that?
Yes, ma'am.
Okay, and that's what you want to do.
Yes, ma'am.
All right, thank you. Sorry, thank you very much, Mr. Coe. Mr. Mayor?
Thank you, Judge. And again, that was going to be my first line of question, but I'm glad we've got that out of the way. So if I may proceed, Your Honor, I will go ahead and do so.
Please.
Thank you. Good morning, Mr. Cargill.
Good morning.
You and I have never spoken about this case before, other than exchanging a couple of letters regarding trying to get Mr. Gross's file, correct?
Correct.
But personally, you and I have never spoken. In fact, you and I have never met before prior to today. Is that correct?
Correct.
Okay. Let's start off with just some basic information, Mr. Cargill. First and foremost, are you a licensed attorney to practice in the state of Texas?
Yes.
How long have you been licensed?
November of '93.
Have you ever been subject to any sort of disciplinary action by the State Bar of Texas?
No.
Are you board certified in criminal law?
No.
Are you board certified in any specialized areas of the law?
No.
How long have you been practicing and handling criminal cases?
November of '95.
I'm
You
sorry,
broke up
Mr.
on,
Cargill, you broke up a little bit. Could you repeat your answer, please?
November of 1995.
Thank
Okay.
you.
and in as an attorney handling criminal cases, are you appointed to criminal cases by judges throughout the state of Texas?
Only judges in Anderson and Houston counties.
Okay. And how long have you been accepting appointments from judges in those counties?
Since on Anderson County since November of 1995. Houston County, I believe it would probably be year 2000.
What percentage of your criminal cases are you appointed versus being retained by individual defendants?
About 35%.
Okay, and approximately, just on an average, how many cases would that amount to on an annual basis?
In Houston County, probably 40. Well, are you talking about cases or individual defendants? Because some
Individual defendants.
probably 40, and in Anderson County, probably 60.
So that's a total of 100 defendants that you're appointed to represent in the course of a year, more or less, on an annual basis.
That's correct.
All right. I want to start by, do you have your affidavit? Do you have the affidavit that you prepared in this case in front of you?
I do.
Okay. I want to start by asking you some questions about that affidavit. And I'd like to start from the beginning of the affidavit. You note on the first page of the affidavit that you were appointed to represent Mr. Gross on March 4th of 2015. Is that what you state in your affidavit?
Yes, sir.
Okay. That is not correct. Would you agree with that?
That is what I looked up and the record told me at the courthouse.
Okay. So if I were to show you the order appointing counsel in this case, and it would show that you were actually appointed in December of 2014, would you have any reason to disagree with the fact that Judge Fletcher, there's an order signed by Judge Fletcher indicating that you were appointed in December of 2014?
No, I wouldn't have any disagreement with whatever the order that she has. I'm going by the court coordinator, or the indigent coordinator had told me it was March 4th, 2015.
All right, Your Honor, at this time, I'd like to publish applicant's exhibit number 65, which you've admitted into evidence, and just put it, display it on the screen share.
You may hold on just a minute. Let me see if I have the screen share turned on.
Yeah, it is turned off.
You should be able to share now if you'll try.
Thank you, Your Honor. I'm good. Okay, for purposes of the record, I'm now going to publish what has been marked as State's Exhibit number 65. And this appears to be, you would agree, Mr. Cargill, this appears to be your attorney fee voucher. Can you see that?
Yes, sir.
Okay, and you can see right down here at the bottom, as far as the time period of service rendered, 12/13/14, correct?
Yes, sir. I see that.
Okay. So now that we've pretty much established, and
Mr. Gross, that is admitted into evidence. And I know you said 12/13/14. I believe it actually said 12/3/14.
and I realize that I keep misstating that. I apologize for that.
Okay.
December 3rd of 2014 is when it actually shows that you started your representation, correct?
Yes, sir.
And the order appointing you, this is in the clerk's record. It's not admitted, but you do see this order appointing showing that Judge Fletcher did sign the order appointing counsel December 3rd, 2014.
Oh, I'm sorry.
Oh, sorry. I took it off too quickly. Sorry. I'll bring it right back. Nope, nope. Hold on. Stop share. Screen 4. Share. Cancel. Are you? Oh, there we go. Okay, and I'll zoom in on it.
I'm trying to see what date it was filed on the right hand side.
Sure.
There. Do you see where it says March 4th, 2015? That's because even though I was appointed, and that's why I put the bill dated that date, because the auditors require the date that you were appointed to.
Mhm.
This is why I put that my representation started on March 4th, 2015, because that's when I received the appointment.
Okay.
I might have been appointed prior to that, but the actual notice of appointment was when the clerk sent it to me, which obviously must have been March 4th, 2015. But that's where I got that date from.
All right. Well, here's the thing.
The indigent coordinator goes by as the date that it was filed in the court.
Okay, well, here's the thing, Mr. Cargill. Judge Fletcher appointed you on December the 3rd, correct?
According to that, yes, sir.
And you acknowledge that by putting that on your voucher that was admitted as exhibit number 65, correct?
Yes, sir. As I explained, the reason why that date is there is that's what the auditor requires. The auditor may be different than the indigent coordinator's date or the date that the attorney receives notice of his representation.
Here's what I'm getting at, Mr. Cargill. When you say that you were appointed, when your affidavit says that you were appointed to Mr. Gross's case on March 4th, 2015, that is not an entirely accurate and credible representation. Would you agree with that?
I would think that it is the best, to my knowledge, representation. I should have put that I was appointed in December and I had knowledge of the appointment on March 4th, 2015, when it was sent to me, and obviously shown that it's filed.
So you would agree that your affidavit doesn't fully set out the circumstances regarding your appointment to Mr. Gross's case?
To the best of my knowledge, it was, yes. That's when, it depends on what your definition of when you're appointed. Are you appointed when the judge appoints you and you don't know about it? Or are you appointed when the judge appoints you and you know about it? Because obviously it wasn't filed until March of 2015. I don't know why I didn't receive the actual order of appointment until then.
Again, just to wrap this up, your affidavit doesn't explain all of that in detail, correct?
Correct.
All right. Let's move on from that point and let's talk about the end of your representation of Mr. Gross. Your representation of Mr. Gross, to your recollection, was it in July of 2016 when you sent him a letter notifying him that the Tyler Court of Appeals had affirmed his conviction?
The representation on the appeal, yes, sir.
Okay, and I think this is pretty abundantly clear in the record, but you continued to represent Mr. Gross after he was convicted at trial, after he was sentenced. You continued to represent him on appeal. Is that right?
That's correct.
And part of your duties as appellate counsel was to continue representing him and notifying him of the appellate decision in his case. Correct?
Correct.
So after July 20th, 2016, when you sent him the letter, did you terminate your attorney-client relationship or take any steps to terminate your attorney-client relationship with Mr. Gross?
I notified him by letter, as we do and required by the Supreme Court, that this is his decision and that we are no longer appointed to represent him in any further appeals, but he could file a pro se petition.
Right. Okay. And
Correct.
and so that we're clear for the record, you did not have anything further to do with him as far as a petition for discretionary review to the Court of Criminal Appeals.
I don't believe I did.
Okay. When you sent him that letter, if I was to, according to the clerk's records, that record was sent to him July 20th, 2016. You wouldn't have any reason to dispute that being the last day that you represented Mr. Gross.
Not if that's the date of the letter.
Throughout the course of your representation, Mr. Cargill, did you keep a file related to Mr. Gross's case?
Actually, I kept two different files. Yes.
Okay. Can you explain that to us?
Well, you keep a file that is the actual trial file, and then you keep a file. Something goes on appeal, the appeal file.
Okay.
And the appeal file is put into the back of the trial file physically, but there's two separate files.
Let's focus on the trial file for a second. And can you tell us what's contained within that trial file, or what you refer to as the trial file?
I don't quite understand the question. Do you mean in general what is contained in a trial file that we have, or what do I remember that's contained in Mr. Gross's file?
Let's start generally what's contained within there, and then I'll see if we need to ask any questions about Mr. Gross's file.
There's several sections. The first section would be the indictment, any amendments to the indictment. The second section would be the appointment and any correspondence from the court. The third section would be any open active pleadings from the state. The next section would be any pleadings that we filed. The next section would be the answer to the discovery that the state has, beginning with the standard discovery order from the county. And then after that, the discovery that they produced. The next section would be any correspondence that I have with my client, both to and from. And then the last section would be any exhibits that we may present or put in, or evidence, or witnesses with what they may say or may not say.
I want to talk with you about correspondence with client, in terms of that section of the file. And I'm talking generally, I'm not talking about right now yet about Mr. Gross's, but what would you have in there? Letters, emails? Would there be a record of text messages? Tell us a little bit about what would be kept in that section of the file.
There wouldn't be any text messages. There would be letters. Usually when I have correspondence from a client, that's usually going to be, if they're incarcerated, they write a letter, and I put that in there.
Okay.
I don't tend to have correspondence from a client unless they're incarcerated.
Now, again, we kind of glanced at, State's Exhibit, Applicant's Exhibit 65, your attorney fee voucher, which kind of has a track of time that you've spent putting into the case. Do you keep any sort of log or record in your file of what you were actually doing on the case? Whether it's reviewing an offense report, going to meet with the client, anything like that?
It depends. Usually what I do, if we have a hearing date and say there was a motion or something, I'll put the amount of time of the hearing in the right-hand corner of that paper. I'll just jot it down while we're having the hearing. If there is a correspondence and I answer the correspondence, I jot that in the right-hand corner of the piece of paper. Any other conversations, I'll usually just throw a sheet of paper in there and say, oh, on 12/13, I spent, quarter hour talking to client. I'll put that in there. That's generally how it's done.
What about offers? You're well aware as a criminal defense attorney the importance of offers that are made to your client and conveying those offers to the client. Would you keep records? Would you keep records or notes of when offers were conveyed by the state and whether you conveyed those to your client and whether they accepted or rejected those offers?
Yes. The district attorney's office, both in Anderson and Houston, and actually everywhere I practice, they give you a written offer that you sign for. If our client's incarcerated, we go down there and talk to them, show them the offer, see what their response is. Sometimes that offer is given to us in court, and counter offers and offers are given orally. We go talk to our clients then. That wouldn't be put the file. But generally, if we have the written offer, we put that it was either accepted or rejected. And by the way that's indicated is I'll put it with a Sharpie, usually trial or no trial, or what the defendant is trying to get. Like, say, for instance, the offer is 10 years and the defendant, he's willing to plead guilty, but he wants probation. I'll write on there, only if probation.
And that would be contained within the file.
Yes.
Okay.
If it's written in there, it's in the file.
Let's talk a little bit about client files in general, Mr. Cargill, and what your understanding is regarding your ethical obligations for a client file. What do you know and understand your ethical obligations to be pertaining to a client's file in a criminal case that you're appointed to represent someone on?
That's kind of a general question, but we keep our files at our office. They're secret. No one other than office staff would have information that's in that file. And some of the information the office staff doesn't even have. They'll have, correspondence and that pleadings and such because they work on those. We keep what we get and put it in the file for safekeeping.
Okay. Just so we're clear, are all the records that you maintain in your files back in 2015, were these hard copies, papers, or were there any sort of electronically stored notes or anything else like that you maintained in your files at that time?
Almost everything is going to be written. Even if we receive something, I print it out because of our capability of computers are not the greatest. Did get some new computers probably 2 or 3 years ago. They're getting better, but as Anderson County can attest, both sides have had issues with computers. It's not as sophisticated as I would like it to be.
Just to kind of, again, I want to make it clear that there's really not like any electronic notes or anything else like that. Everything is.
No, we don't have electronic notes. We just, whatever's printed would be printed out and put in the computer. In the file.
So going back to the client file and everything that you maintain in there, what is your understanding of who the file belongs to what the ethics, what our ethics rules require in terms of who the file belongs to?
Most of the file belongs to the client.
Okay. Obviously, items turned over in discovery, you cannot provide that to the client. You're aware of that limitation.
Yes, sir.
Okay. But anything.
Well, with one exception, if there's discovery that's produced and then the client decides they want to represent themselves, if we get a letter from the client saying, I'm requesting this, I'm going to represent myself, we bring it to if it's during the trial, the proceedings, of course, we bring it to the court's attention and they decide whether the person's going to represent themselves or not. If it's after the trial and they're going to represent themselves on appeal, then we talk to the attorney's office and they either say release it or not release it, or there's going to be an issue.
And again, I don't want to belabor the point, Mr. Cargill. What I want to focus is on the things that ordinarily belong to the client. Would you agree that anything that you produce, okay, as the attorney, that belongs to the client? Would you agree with that?
Yes.
Okay. And how long? I think I know the answer to this question, but how long do you maintain those clients' files for?
What we do is when I get in a file, we assign it a file number, and in each file we'll have the defendant's initial, and then I'll have that file number, and they'll have the year it came in, like whether it's 05, 06, 15, whatever, the numbers will be at the end.
Okay.
Though with a file is what we consider dead, we say, okay, I'm finished doing work. We put it back into we have rolling files in the back of our file room. At the end of the year, we select files that have 5 years or more. Those are gotten rid of. At May, that same thing happens again. So 2 times a year, we have files shredded if they reach the 5-year point.
Okay.
The only files that we don't do that are the will files.
Okay. So when you say the 5-year point, to help the court understand when that 5-year point is met, let's say you have is it when the case is open or when the case is closed?
When the case is opened.
Okay. So does that mean
if it's over, some cases open in, like, for instance, we have misdemeanors on the misdemeanor docket now that are 18 years old. Since it's closed, the file hasn't been destroyed.
Okay.
Because it's still open.
But are you saying that if you had a file that opened up in, say, 2010, but it took 4 years for the case to reach a conclusion, are you saying that your policy would be that 1 year after the conclusion of the case in 2015, that's when the file would be destroyed?
Correct.
Okay. Do you feel that complies with your obligations under the ethics rules?
I do.
Okay, that's fair enough. So we had this. This goes back to what I first started about. Did you open your file for Mr. Gross in 2014 when you were appointed, or in March of 2015 when you said that you received notification of the appointment?
We would have opened it when we received the notification in March 2015.
Okay. In August of 2020, last year, you received a letter from Mr. Gross requesting that you provide him with his file by providing it to his attorney, namely Mr. David Moore. Is that correct?
That's correct.
Okay. You responded to Mr. Gross by stating that you generally shred files after 5 years of closing and that you would have to look for the file. Is that correct?
That's correct.
And did you make any efforts to locate the hard file in this case?
We did.
And what did you learn from that?
That the file was shredded in May of 2020.
Okay. Now, and that would have been consistent with your policy, with the case having been opened in March of 2015, correct?
That's correct.
All right. How do you go about destroying those files? Do you go in and shred them yourself? Do you call in a company? Do you instruct your assistants? How do you do that logistically?
Recently, well, not recently because of COVID. Now we had to burn them because the shredding company wouldn't come. But we've had a shredding company come. We also do our own shredding, and then we burn them at my place out in Slocum.
Okay. This would have been, with Mr. Gross's case having been completed in July of 2016, this would have been less than 5 years from that date, correct?
Yes.
All right. Now, I want to turn back to your affidavit. In your affidavit, on on page 4 of your affidavit, in the first paragraph, you attest to this. I also believe that this writ is politically motivated because Mr. Moore requested a motion to release PSI on behalf of his client on May 9, 2018, correct?
Correct.
And then in February of 2019, Mr. Gross wrote a letter to the court. Is that right?
Correct.
And so it's fair to say that prior to you destroying the file in May of 2020, you at least had some indication that someone was looking into Mr. Gross's case to determine whether or not any further action needed to be taken, correct?
No, that's not correct.
Well,
When,
let me hold on. Let me ask the next question. So, Mr. Cargill, you've been doing this for a long time. Do you know what a writ of habeas corpus is?
I do.
Have you ever prepared, filed, and prosecuted an application for writ of habeas corpus pursuant to 1107 of the Code of Criminal Procedure?
I have.
Have other past clients of yours filed 1107 applications for writ of habeas corpus against you in the past?
Yes.
You would agree that destroying your file is sometimes beneficial to your interest and not the client's interest when it comes to resolving issues related to the allegations in a writ of habeas corpus.
No, I wouldn't agree to that.
You would agree, well, let me ask you this. You would agree that your records of the work that you did on the case is going to provide the best record. Okay, it's like an offense report. Your notes are being made at or near the time of the event. Agreed to that?
Correct.
So you would agree that your notes and the work that you've done on the file is going to be the best record of the work that you have done on an individual's case.
That's correct.
Okay.
I think that if I had that file, it would be easier to defend this writ.
Okay. And this isn't your first writ that you've had to deal with, right, Mr. Cargill?
It's the only writ that I've had to deal with like this. Yes.
Okay. But you've had allegations made against you before, and have you had to go back to your files in order to have something to show what you did or you didn't do?
No, generally, I've only had a few of these, and they were limited to certain things like was this explained or that? We ordered the record and that was shown, or was this communicated and it was shown on the record?
Okay.
I don't really recall any time that I've had to do anything other than a short affidavit on any 1107.
Okay. Let's put aside writs of habeas corpus for a bit and let's just talk about, our roles as criminal defense attorneys. Okay. You've represented hundreds, if not thousands of people charged as criminal defendants, correct?
Correct.
You represent people who are accused of crimes and who are investigated by law enforcement every time, correct?
Usually, sometimes they're not investigated, but yes.
If you as a criminal defense attorney discovered that the police destroyed records related to their work investigating a client of yours, would you as a criminal defense attorney see that as a problem?
It could be, yes. It happens. Not as much as it used to, but in recent past, if a car, say for instance, you wanted a DWI video and it was going to be beneficial to your client and you asked the state for it, and sometimes the police officers taped over it or it was destroyed in some factor. Yes, sometimes that creates an issue. It depends on, I've never pursued anything because I've never had the experience that it was intentionally destroyed.
But you would agree that it nevertheless creates a problem for your clients whose liberty are at stake, right?
Yes, sir. I definitely believe that anytime any record or anything that would memorialize what went on is destroyed, it creates a problem for everyone.
Okay. Let's talk about let's go back to Mr. Gross's case now, and let's talk about the time leading up to the trial. Let me pause here for just a moment. Your Honor, if I may, I think I had represented to you, and I know I represented to Mr. Coe, that I did not think that my cross-examination was going to take longer than an hour. I'm looking at my notes, and I'm making some considerable progress, but I'm a little bit behind schedule on this. So I just wanted to let you and Mr. Coe know that I probably am going to run longer than the initial hour that I had planned, but I'm trying to get through and make the points that I need to make and get the information that I need. So
thank you for letting me know that, Mr. Mayor. I would say we didn't start promptly at 9. We were all on at 9, except for Mr. Gross, and he had no control over whether he was on, waiting to have the WIN unit make their Zoom link available. So I don't think you started it straight up 9. I neglected to note when you started. And so you have me at a disadvantage because I can't say your hour's up.
okay.
So we'll just say an hour from now, we know for sure you've been going more than an hour.
I like that. I do not think that I'm going to take longer than an hour from this point, but let me continue working, and I just wanted to let Mr. Coe and let anyone else know in case there was anything else that they needed to attend to. Okay, so if I may continue, Your Honor, I'll go ahead and do that with Mr. Cargill.
Please.
Thank you. So, Mr. Cargill, let's talk about your time representing Mr. Gross and the time that he's leading up to the trial. You had met with and spoken with Mr. Gross regarding his case prior to him going into custody in June of 2015. Is that correct?
That's correct.
Okay. And as you stated in your affidavit, you do recall that he was taken into custody when he failed to appear for a court appearance. He was taken into custody on June 8th of 2015. Is that correct?
That's correct.
All right. Prior to that, as you stated in your affidavit, you maintained that Mr. Gross was not pushing for a speedy trial. Is that a good summary of what his position was in terms of wanting to go to trial or not wanting to go to trial?
When he was not incarcerated, he was not moving to go to the trial. Correct.
And
he wanted to stay out as long as he was out, he was fine.
yeah, as most defendants are, right, Mr. Cargill?
Yes, sir.
Good. All right. And in the time prior to him being taken into custody, you all had made your initial and subsequent appearances all in front of Judge Pam Foster Fletcher. Is that correct?
Yes, sir.
All right. Had you all ever appeared before any other district court judges there in Anderson County?
I don't believe so.
Okay.
But
And if there's nothing in the record to reflect that, you would agree that's consistent with how you remember it, correct?
yes, sir.
After Mr. Gross was taken to custody on June 8, 2015, his next court appearance with you would have been on June 19th, 2015. Is that what you recall?
I don't have it in front of me, but if that's what the record shows, yes.
Okay, no reason to dispute June 19th, 2015. According to your affidavit, that is when Mr. Gross insisted on his right to a speedy trial and wanted a quick trial setting. Is that correct?
Yes, if that's what it reflects.
And if you need to, you have your affidavit. If there's any other records that you'd like to look at to refresh your memory, I'll be more than glad to provide them for you, Mr. Cargill. Just let me know.
Yes, sir.
Okay, so everything that's taking place on June the 19th, again, that's in front of Judge Fletcher.
Yes, sir.
All right. Judge Fletcher scheduled the case for trial on July the 13th, correct?
Yes, sir.
And
I'm agreeing with you because I'm assuming you're looking at the record. I don't have the.
In your affidavit, you state that Mr. Gross picked that date. Really, that was Judge Fletcher picking the date to accommodate Mr. Gross's request for a speedy trial. Is that correct?
Yes, but the way it goes is we didn't have to do that. The judge says, okay, I can give you this date, or this date.
Okay.
The defendant gets to, request unless the state says, oh, I can't be ready on that date, or the defendant says I can't be ready on that date. So it's kind of a date. They usually give you 3 dates.
So we'll call it a collaborative effort. Is that fair to say?
Yes, sir.
Okay. Now, to your knowledge, was a record made of the proceedings on June 19, 2015?
I would assume.
Okay. If I were to tell you, well, let me ask you this. Explain for the court and for the record what the procedures are in Judge Fletcher's court as far as taking a record. In other words, is there a court reporter taking all proceedings taking place in front of her, or does the court reporter come out for limited things? Back in 2015, how did that work in Judge Fletcher's court with the court reporter?
It generally, everything was taken. Some things wouldn't be taken. Some things would be discussed in her office. Some things discussed at sidebar. It just depends on what it is.
Okay.
But yes, the court reporter is generally there. She's never there for the first part of the jury selection process where you are qualifying the jury.
Mm-hmm.
She's not there for certain other things, scheduling things, stuff like that.
Yeah.
But generally she's there.
But for the most part, in court proceedings, let me just put it to you this way. Do you know who Judge Fletcher's official court reporter was at that time?
I believe it would be Misty.
Okay. And so I'm going to represent to you and to the court that we requested from Misty her transcripts of every proceed. Let me back up. Do you recall when you handled Mr. Gross's appeal requesting the record of all proceedings involving his case taking place in front of the 3rd District Court?
That's correct. And when the 3rd District Court, we say the 3rd District because at that time all the cause numbers were put in the 3rd District. But when we said that cause number, we meant any judge that had a proceeding for that district.
And I understand that. I don't want to get hung up on that. The main thing is are you
Well-
saying did you request all proceedings that took place, including any pretrial proceedings?
The reason why I said that is I'm not sure it was to Misty. It might have been to Judge Deborah Oaks Evans, court reporter, that we requested the record. That's why I said when we request that, we expect all the records from any judge that had that.
Okay. To your recollection, when you were working on the appeal, as the appellate lawyer, it's your duty to review the entire record of all the proceedings, right?
If you think that there's an error in part of the proceedings, yes. Sometimes you don't ask for the voir dire because you don't believe there's voir dire. Sometimes if you haven't filed any pretrial motions, you don't ask for any of the pretrial stuff. You just ask for the jury selection and jury trial. It depends on where you think there might be error.
All right. So do you recall requesting all the pretrial proceedings in this case from any court reporter?
I do, and I believe that I requested them from Judge Evans, court reporter.
Okay.
Right.
So just so we're on the same page, we requested from Misty McAdams, the official court reporter for Judge Fletcher, all proceedings, and she was able to provide us with transcripts from, one moment, please, make sure I'm getting this correct. From arraignment on April the 6th, 2015. You recall that there was an announcement on April 6th, 2015?
I don't recall that from my memory, but if that's
She has a record of proceedings on May 5th when the case was called and the parties announced that there was not going to be a pretrial. Do you remember that?
yes.
Okay. And then there's a record of the proceedings on June the 1st when the court forfeited the PR bond. That you were in court that day. Is that correct?
Correct.
All right. But she does not, if I were to tell, and do you have any dispute if I tell you that we requested from Misty and she did not provide us with a record from June 19th? You're not aware of a record from June 19th, 2015, correct?
Correct. I'm not aware of any record.
Okay.
Any court reporter's record.
Okay. Now, would you agree that a defendant demanding a speedy trial, that's an important right and a demand made by a defendant, correct?
Correct.
All right. Would you agree that that's something that you would want a record of if the defendant indicating, I want a speedy trial?
On most instances, yes.
Okay. And would you agree that the obligation to have a record of the proceedings made ultimately falls on you as the defense attorney to preserve that record of what is being of the defendant either giving up a valuable right or wanting to invoke a valuable right?
Generally, yes.
All right. Now, you met with Mr. Moore the day prior to that June 19th hearing. Do you recall that?
No.
Okay. You don't remember meeting with him at all?
No. I don't believe I've met Mr. Moore.
I'm sorry, Mr. we all do this. I think the judge did earlier. We all tend to do this. Mr. Gross, did you meet with Mr.
Oh, yes,
Gross?
sir.
Sorry.
Yes, sir. Yes, sir.
Okay, sorry. You met with Mr. Gross. Do you recall meeting with him the day before on June the 18th?
Yes, sir.
Okay, and where was that at?
That would have been at the jail,
Okay.
most likely, unless it was the courtroom.
And
Jail.
okay. And is it fair to say that you do not have any records in terms of any notes or anything else like that regarding what you discussed with Mr. Gross that day before the June 19th hearing?
Correct.
You are now here in late 2020 and into 2021 having to recall the details of what was said because you've destroyed your file that would contain any notes regarding that meeting, correct?
That's correct.
Um,
Generally, though, I may not have made any notes for that meeting, but and the only reason I say that is I don't recall whether I made the notes for that meeting or not. But if I made notes, they are destroyed.
the problem is it's hard for this court or for any court to know exactly what was discussed between you and Mr. Gross at that meeting. Would you agree with that?
Only Mr. Gross and I would know what was discussed. Yes, sir.
And to your recollection, what was discussed at that June 18th hearing date? I'm sorry, the June 18th meeting that you had with him prior to June 19th hearing date.
I can tell you generally when Mr. Gross was in jail, and it didn't matter what the reason to have the conversation was, the conversation began with he wanted to get out of the jail. He wanted to get out as quickly as possible. He wanted to get his stuff moved and done because he was persistent that he would be out of jail.
Okay. And that is, you say generally, but that was if there was one common theme of that conversation that you remember, it was that, right?
That's correct.
He wanted that trial. He wanted it fast, right?
Well, he didn't care whether it was a trial, a dismissal, or bond reestablished. He didn't care whether the actual case was anything about the actual case. He wanted out of jail. That's
Okay.
correct.
Had the state conveyed an offer at that time?
They had.
And what was the offer?
I don't have that in front of me,
And
but they had, the state conveys the offer generally at arraignment, where when we do our arraignment, we walk over there and sign for a written copy of the offer.
well, here's the problem is on June the 18th, you don't recall if there was any discussions regarding the offers to plead, right?
It would have been the same offer to plead that the state had already given.
Okay.
So, and if
But-
they change the offer, then they'll come and they'll say, okay, hey, like at a pretrial or the status, they'll say, okay, we'll accept your counter offer, or this is the new offer. But they generally just keep the offer and it's the same. Yes.
Here again, I want to focus. I want to focus on the June 18 meeting that you're having with Mr. Gross in the jail. Okay.
Okay.
You don't have any specific recollection about the offers to plead and resolving the case that way, do you?
Well, we had the same offer we always did. Yes. But we didn't discuss an offer at that point. He wasn't.
He just made it very clear he wanted out, right?
And I can tell you that the offer was always incarceration in TDCJ. And that wouldn't have been an alternative for him. He did not want jail.
The state was not going to dismiss this charge, correct?
Correct.
You probably discussed that and said, look, the state is not going to drop this case, right?
Correct.
And he didn't want to plead and get sentenced to prison. So that was off the table.
Correct.
Okay. And so did you explain to him that, look, your only other option is to, if you don't want to plead guilty and if you don't want to accept the offer, your only other option is to go to trial?
That's correct.
Did he indicate that he wanted to go to trial on his case?
Yes, if that's the only way that he could get a possibility of getting out. Yeah.
Now I want to talk about the other thing.
If he had the possibility of getting out back on PR bond,
Yeah.
he would have chosen that, but never going to be a possibility because it was revoked.
Another possibility for getting him out was if he were to get probation, correct?
Correct.
And
And
so,
he always thinks, never mind, I'll wait till you
okay.
ask.
He made it very clear to you that he would be willing to plead guilty if he was going to receive probation in exchange for that, correct?
That is correct.
And so is it safe to say, your affidavit doesn't go into great detail about this, but is it fair to say that at that meeting with him on June 18th, you discussed with him what would be required for him to get probation?
Yes, I told him that the jury could not give him probation, and why not? Because he had been convicted of a felony.
Okay, and he would have to swear that he's never been convicted of a felony, correct?
Correct.
And obviously he could not legally do that, right?
Correct.
And you explained that to him.
I did.
You made it very clear a jury cannot give you probation.
That's what I told him, that he would have to swear to that he had never been convicted of a felony in this state or any other state of the United States.
And so based on that, you told them the only person who could give him probation was
the judge.
Okay.
And then, as explained in my affidavit, I told him if the state files a motion to enhance, then the judge could not give him probation. The judge believed that one of those enhancements weren't true, or they couldn't make one of the enhancements.
Okay.
And I explained the judge could do probation, and if he pled open, the judge could do deferred adjudication.
Okay. You explained all of that to him, right?
Yes.
You made that very clear to him what his options were when it came to sentencing, correct?
Yes, sir.
And he relied on your advice to elect to have the judge decide his punishment, correct?
I would suppose he relied on my advice. That's the decision he made.
Right. And because the judge was the only person who was going to be able to grant him probation based on the law, not the evidence, just the law, right?
Yes.
All right. Now, going to June 19th, back to June 19th, and we're in front of Judge Fletcher. Again, that's the same judge that he'd appeared in front of for the entirety of the case, right?
I believe so. Whatever's on the docket sheet.
Okay, so you would agree that, as with most defendants, Mr. Gross had an opportunity to observe Judge Fletcher and her demeanor in the courtroom and seeing how she operated as a judge, right?
Yes, sir.
And so if the decision was going to be that the judge was going to decide the punishment, at least on June 19th, the idea is with you and potentially with Mr. Gross is that it's going to be, if I'm found guilty, Judge Fletcher is going to be deciding my sentence.
Except for if I don't remember, because I'm not looking at my affidavit, what date that the judge was changed.
Okay.
But yeah.
Well, that leads to my next line of questioning. So let's talk a little bit about that.
That he did like Judge Fletcher.
Okay, well, that's good. I'm glad that I appreciate you sharing that. And I'm glad. I thought that point was he obviously, and he liked her because he had been in front of her and had seen her demeanor and knew basically what he was getting in terms of who was going to be deciding his sentence.
Well, I think Mr. Gross had been in front of almost every judge.
Okay, but at least for this case, he had only been in front of Judge Fletcher.
Yes, sir.
Okay. Now, so let's go to that. Let me ask you one other thing about June 19th. Allison Mitchell was always the lead prosecutor on this case the entire time that you were handling it. Is that what you recall?
I guess. I can tell you that Allison and Scott flip back and forth. They even do that now. So there's not like a lead prosecutor. If I go to the office, generally I go up there and I say, can I speak to somebody on this case? Whoever's available, whether it's Allison or Scott, talks to me. Unless it's a sex case, then it's only Scott.
Okay. So on June the 19th, was Brian Evans present or involved in this case at all on June the 19th at that pretrial hearing?
I don't think Brian was there.
Okay.
I don't think so. He might have been, because he was doing observation and helping with the district judges at that time, thought that he was going to be their third prosecutor for
Okay.
the district court.
When did you become aware that Brian Evans was going to be involved in the trial of Mr. Gross's case?
I don't remember the exact date, but it was prior to jury selection.
Day before jury selection, 2 days before jury selection?
Like I said, I don't remember whether it was discussed at the day of jury selection or it was a few days prior, but it wasn't much prior, I don't believe.
Well, then let's change gears and let's talk about Judge Evans, because this is something that is not addressed in your affidavit, okay? In your affidavit, there's no mention of when you learned that Judge Evans was going to, and just so we're clear, that affidavit is your opportunity to sit down and to comb the cobwebs in your mind to recall as much detail as you can about this case, correct?
Correct.
And respond to the allegations in the writ application,
Correct.
and include.
Except for I haven't gotten a copy of the second writ application, only had the initial. And that's when I did this affidavit. So,
Okay. But still, I mean, that's your opportunity to list every single detail that you can recall, correct?
well, every detail that I think is pertinent at the time, yes.
Okay. And so obviously the biggest complaint here is Judge Evans' involvement in this case with Brian as her son being the prosecutor. You weren't able to state in your affidavit when you learned she was going to be trying this case, right?
Oh, that would have been just at that time, all the had their different weeks and they still do. They have their different weeks of the month that they try cases. And at that time, if you chose a week, it would be that judge. Now, and this started probably 3 or 4 years ago. Now, if you are a computer assigns you to that judge, you have to be in that judge for all the pretrials and the trial setting. Before, everything was assigned to the third court, and then whatever judge was that your date came up on, that was the judge you were assigned to. There would be some cases where you're arraigned by one judge, pretrial by another, and tried by another.
Okay.
But whatever date is what controlled what judge it was. So I would have known that it would have been Judge Evans.
Okay. Let's again make some things clear for the record. First and foremost, the docket sheet does not make any reflection. There's nothing reflected on the docket sheet that the case was going to be tried in front of Judge Evans. Would you agree with that?
Correct. It's just that's what selected the judge.
Let me just ask the questions here really quick. So there's nothing in the docket sheet reflecting that the case is going to be tried in front of Judge Evans.
Correct.
There's no reporter's record of the proceedings on June 19th. Just tell us whether there was any discussion that Judge Evans would be the judge trying the case.
There wouldn't have been on the record like that. No.
Okay. And there's nothing in your affidavit saying explicitly that I knew on June the 19th that Judge Evans was going to be the judge in this case. That is not reflected in your affidavit.
No, I didn't put that in my affidavit. It would have been true because that's the person that was that week.
Okay. So you know that is who the judge is going to be that week. How?
Because that's how the judges were assigned. Judge Evans does Anderson, Freestone, Leon, and Limestone.
Right.
And he only has one trial week a month, and that's always been her trial week.
Sure. And this might sound a little elementary, but how do you know that?
Because that's the way the court coordinator has the docket set up.
Okay. And that's what I need. That's what I need the record to reflect. So the court coordinator has some sort of a sheet or some sort of that shows this is who the judge is going to be on that week?
Yes, well, except for if it's always the same week. It's always the same non-jury days and always the same week, unless they do some special setting by request and give up some days in another county, or unless a jury trial goes longer than their scheduled week.
Okay, but this is all all of this information is maintained by the court coordinator in her office, either by asking her and she tells you, or there's some sort of a sheet that you can look at to see who the judge is going to be.
Yeah, you ask her, but I mean, then
Okay.
the same. So we just generally know that, but yes.
Okay. So it is now your representation that you knew some point prior to July 13th that Judge Evans was going to be the presiding judge in this case.
Yeah, whenever the date was set for July 13th, I would have known it was Judge Evans. Yes,
Okay.
it's Judge week.
Okay. Now, your affidavit likewise does not reflect any discussions on June the 19th with Mr. Gross that, oh, by the way, it's not going to be this judge, Judge Fletcher. It's going to be another judge, Judge Evans, presiding over your case and potentially deciding your punishment. Your affidavit doesn't have any reference regarding any discussions about that on June the 19th, correct?
Yes, correct. It doesn't say anything about it.
In fact, your affidavit doesn't make any reference as to when the discussion was had with Mr. Gross regarding the fact that it was going to be a different judge presiding over his case, correct?
Well, except for, obviously I talked to him on June the 19th. And then also I put that you could look at the jail visits that are reflected in the jail log down when I made the jail visits after 19th.
Okay.
But yes, it was discussed, but I don't remember. I'd have to think back when it would have been discussed, but I'm sure on June the 19th, if he chose the next trial date, I'm sure the judge probably would even said who was going to try the case.
Okay.
But known on that day if it was going to be June 13th.
Really quick, Mr.
July 13th.
Really quick, Mr. Cargill, just to put this into perspective, at that time in 2015, Mr. Gross isn't your only criminal case that you're handling at that time, correct?
He's the only one I'm handling for the trial that month. Yes.
Sure. But you are responsible for close to 100 other criminal defendants that you've been appointed to represent, not to mention the rest of your retained docket. You have a lot of other clients whose cases you are managing at that time in June and into July of 2015. You would agree with that, right?
I would agree with that. Maybe not, but yes, I'd agree with that.
Mr. Gross, his only criminal case was this case, correct?
No, actually, I think he had some other cases. If you had asked me that before, I would have told you.
Okay.
But I imagine Mr. Gross always had some misdemeanors that were always pending and other things. But this was the only one that he had that was going to jury trial. Yes, sir.
Okay. And he's sitting in jail, so all he has to think about is this case that he's about to go to trial on, correct?
That is correct.
That's the only thing on his mind at that time.
That is correct.
Okay. Now, do you recall meeting with Mr. Gross the night before trial or the day before trial started on July the 13th?
Well, yes, I would have met with him before then.
The day before?
Yes.
Okay. And that's what your recollection is?
Yes, and probably before that.
Okay.
Just a minute. I wanted to clear up. I didn't understand Mr. Cargill's answer to that. I think the question was, did you meet with Mr. Gross the day before? And then you said before the trial date. Would you ask your question again, Mr. Mayor? And
Yes.
Mr. Cargill give another answer, or just one that I can understand?
Sure. You did, you're affirming that you did meet with Mr. Gross the day or the night before trial started on July the 13th, correct? Mr. Cargill, did you hear my question?
I answered.
Oh, I'm sorry. We didn't get the answer.
Oh, I said yes.
Okay, sorry. I didn't hear an answer, so that's what I was waiting for.
As far
Okay.
as the timing of that, the jail log would reflect the best record. That's why
Okay.
I said jail log.
And in terms of Brian Evans' involvement, you said that you knew before that Brian was going to be involved, but you can't remember exactly when he was involved. Is that right?
That's correct.
Okay. It may have been the day before. It may have been 2 days before.
That's correct. It wasn't on June 19th. No.
Okay. Okay. So let me do this. I'm going to I may just have one moment, Your Honor. Let me get this here. Your Honor, I need to clarify exhibits at this point. We're through 60. I did not offer 65. No, I'm sorry. I did not offer. Here we go. We're through 67 is where we're at. Is that correct?
That's correct.
Do you 68? We talked about a possible 68, but nothing was offered in regard to that. So let me just do this just to make it real clear. I'm going to offer what I'm going to mark as states exhibit number 69. I'm sorry, I keep saying states. I don't know why. I'm going to offer applicants exhibit number 69, which if I can tender, I don't know how to, I'm trying to figure out the best way to do this. Let me just state what it is and we can go from there. This is an affidavit for business records, which attest to be the records of the jail visits. I guess I can publish it and let the state look at it, and then the court can entertain any objections. I don't know how to best go about doing this, Your Honor, but I'd like to offer this as applicant's exhibit number 69.
Well, or really, the best way to do it would have been to tender it to the state before today, so they would have an opportunity to look at it. How many pages is it, Mr. Mayor?
Judge, 2 pages.
All right. Why don't you share the screen and show it to, I believe Mr. Holden's made the objection on this witness, so he'll be able to make an objection on this.
Okay. So for the record, I'm going to tender via screen share to the state applicant's exhibit number 69.
I can see the affidavit, but I can't see the next page.
Gonna get there. You let me know when you need me to go, Scott. Here you go. This is the second page, and I'll show this is the entirety of the page right here.
Can you show me the first page again, please?
Sure.
I have no objection to this document.
Applicant 69 is admitted.
And at the conclusion of the hearing, Your Honor, I'll email this to the court and to the court and to all parties so that they have a copy of this exhibit.
Thank you.
Okay. So now,
if you said court reporter, but make sure you actually tender it to the court reporter because she's the important one.
Of course. Thank you, Your Honor. Okay. So, Mr. Cargill, I'm going to zoom up on page 2 of this. This is what has been attested to by a business records affidavit of the records maintained by the custodian of records for the Anderson County Jail.
Yes, sir.
And we can see here all of the visits that you had with, that you, Mark Cargill, had as the attorney with Mr. It says Richard Ross, but we know from all the other information here that it's Richard Gross, correct?
That's correct. That would have been the jail visits I had with him.
Sure. And so we see a visit here on June the 18th, which would have been prior to the June 19th court date, correct?
Correct.
We see a visit here on July the 8th, 2015 at 8:32 p.m.
Yes, sir.
Okay. And we see that the next visit isn't until after trial has started on July the 13th at 8:03 p.m. Correct?
Correct.
All right. So according to these records, Mr. Cargill, it does not show any visit that you had with Mr. Gross at the jail the day before trial started on July the 13th, the day before that on July the 11th. The only time you had met with him at the jail, according to the records, was 5 days prior at 8:32 in the evening. Is that you would agree that's what these records show, right?
I would agree. That's what the records show. Yes, sir.
And you've continuously maintained that that's the best record of when you went to saw Mr. Gross, right?
It would be, yes.
You don't have any file or notes in your files to dispute those representations in those records, correct?
No, I wouldn't.
Okay. So let's go back and is it safe to say that if you had only learned of Brian and Evans' involvement in this case a day or two prior to the trial starting on July the 13th, that the only time that you would have had visited or discussed Brian Evans' involvement in this case would have been the morning of trial, July the 13th? You're on mute, Mr. Cargill. Mr. Cargill, you're on mute.
Yes, if I learned of it then that would be the only time I would have talked to him about it.
Okay.
However, I must have learned about it when I said a few days. 5 days would have probably been a few days. When I go to visit someone at 8:32 p.m. at the jail, it's something very important, or I wouldn't be going there and driving 45 minutes to go there and see somebody.
But you obviously didn't meet with him the day before his actual trial was going to commence, according to the records, right, Mr. Cargill?
Correct.
Okay.
Unless the jury was selected on the 13th and then the trial started the 14th, I don't have the records in front of me.
Okay. But before you even start jury selection, before the trial commences, before his fate is about to be determined, you haven't met with him the day before or the day before that, right?
That's correct.
All right.
I met with him on the 8th.
So,
and the day
we know
after, the day after, or the day of jury selection.
So let's be clear about this, okay? We know for certain, or almost for certain, that you visited him on the 8th, okay? But what we don't know for certain is when you had the discussion with him regarding Brian Evans. Your affidavit doesn't make any reference. Let me ask this question. Your affidavit does not set out in the detail that you're putting into this affidavit when you had this discussion with Mr. Gross regarding Mr. Brian Evans' involvement in this case. Is that correct?
Correct. It doesn't have a date, but
Okay.
if that's the only time I met with him before trial, and it was a few days before trial, then that would have been the date. Obviously, I met with him several times before that date, but the only time that I met with him after we would have had a court date set that he would have been in jail would have only been July the 8th.
But
That's
you cannot state, you could not state in your affidavit, and you cannot state right now with any reasonable certainty, attest to the fact that you discussed Brian Involvement's case with Mr. Gross anytime on July 8th when you went to see him at the jail, correct?
I can tell you that I discussed it with Mr. Gross, and it was prior to trial. If that's the only
You cannot say exactly when that conversation took place.
again, I can say that I discussed it with him, and it was prior to trial. If there is only one date that would have been available, then it would have had to be on that date, July the 8th.
So you didn't have an opportunity to speak with Mr. Gross the morning of trial?
I would have had an opportunity before the jury selection began, or during the qualification of the jury, and then as we're doing the jury, and obviously throughout the entire trial.
But I want to be clear about this. Again, what you're testifying to is that your logic is that you would have discussed this with him, but you can't swear to the truth, being that you had that discussion with him on July the 8th, right? You would have put that in your affidavit.
What I put in my affidavit, and what I'm sure of, is that I discussed it with him, and then it was before trial. If the records show the only opportunity that I met with him other than the day of was July the 8th, then that would have had to be the date.
Okay.
I didn't have no log record to indicate
Hold on just a minute, Mr. Cargill,
when I met with him,
Hold on, Mark.
David, or this is the first.
Cargill,
hang on just a second, Mr. Cargill. I'm going to need you
Yeah.
to back up and repeat that answer. You were garbled for part of that answer.
Yes, ma'am. What I'm saying is I met with Mr. Gross and discussed the issue of Brian Evans and all the other issues of court prior to the trial. If the only date that shows on the jail record was July 8th, that had to be the day that I discussed with them. That would be the only way that I could reconcile the fact that I know that I discussed it with him. I didn't have the jail log with me at the time that I did the affidavit. The first time I've seen the jail log is when you put it into the record just then.
okay. Let's make this clear for the record. On July the 13th, Judge Deborah Oaks Evans was the presiding judge, and her son, Brian Evans, was one of the assistant district attorneys who was going to be prosecuting the case at trial. Is that correct?
Yes, my understanding is that Allison had him do one witness.
Right, but he was nevertheless a participant in the proceedings, correct?
Yes, he was.
And you knew, I think this is clear, I just want to make it clear for the record, you knew that he was Judge Evans' son.
Yes.
Natural born son, not adopted son, not half son. I mean, he was not stepson. This was her biological child. Is that correct?
Well, I don't know that, but I know that that's her son. Yes.
All right.
I don't know whether he adopted him or anything.
Okay.
But
Fair enough.
Yes.
Let's put aside for just a moment, Mr. Cargill, Judge Evans and Brian Evans. Okay. Let's put aside just July 13th for just a moment. Okay. I want to ask you personally, okay, how you would feel, okay, if you or a loved one were on trial with your or your loved one's liberty on the line, and the prosecuting attorney that was trying to take away yours and your loved one's liberty was the son of the very judge who would be presiding over your trial and deciding your sentence if found guilty. How would you feel about that personally?
Objection, rank speculation.
Sustained.
I'm asking what his personal belief is. I think he can testify as to what his thoughts were.
Mr. Holden, do you have any other objection?
Goes to the ultimate answer in this case, and furthermore, it still will be speculation trying to put himself in the shoes of this defendant.
No, I'm
He's
not asking.
him to put him, hold on just a minute. He's not asking him to put himself in the shoes of this defendant. He says, what would his views be?
It's still subject to speculation because he has to speculate what his views would be.
Well, as to his views, that's denied. That's overruled. Any other objection?
Relevance?
Sustained.
Your Honor, I believe, if I may, I believe it is relevant because I think it's going to tie into the importance of the advice that he's going to give to him. If he thinks that this is something that would be important to him, it might give some bearing on how forcefully or what sort of advice he gave to Mr. Gross.
Your objection was overruled.
Can I answer the question or do I
No,
answer?
not answer the question. The question is, there's been an objection sustained to the question.
Okay. Would you agree, Mr. Cargill, that this is a highly unusual situation to have the prosecutor as the child of the judge that they are appearing before?
I guess. Yes.
Okay. And you never had encountered, is it safe to say that you'd never encountered this situation before in your entire practice as an attorney?
No, that wouldn't be true.
Prior to this, you had been in front, are you saying that prior to this situation with Mr. Gross, that you had handled a case where the prosecuting attorney was related to the judge handling the case?
I believe so. I would have to look at my records, but for instance, Judge Calhoun, I believe, has had cases where Mark Calhoun was either the prosecuting attorney or on a civil case, and then I would have to look at any other times. We've always had father-sons type situations. And so I don't know. I'd have to look. I wasn't asked that question before, so I haven't looked back in any records or any memory, but, Brian had been before Judge Evans before, I can tell you that.
Okay. On a case of yours?
No, I don't think so, but it might have happened. Yes. I'm not positive. I just know that he had.
So let me ask you then this, Mr. Cargill, based on your experience with the situation, can you tell this court what, as an attorney, okay, what do you identify as being the constitutional or statutory rights at issue in a situation like this, where the prosecutor is the son of the judge presiding over the case?
I think that if the defendant wants to protest, then a protest could be made. And then if the judge disagrees, then it would go to the administrative judge, and the administrative judge would decide. If the administrative judge decided that a new judge needed to be appointed, then they would. If the judge agreed to the protest, then she or he would step aside. But I believe that it's the defendant's right to object, no matter if it's the son of the judge or anybody. Sometimes they object if they just think they're too friendly.
Okay. So let's talk about this proceeding. When you say they object, tell us how is that? How do you object? What is that?
Well, they tell their attorney, and the attorney either does a motion to recuse, or you can do it informally and say, Judge, my client's not comfortable with you hearing this case because this. Are you going to be willing to step down? And if the judge isn't willing to step down, then you file a formal motion to recuse. The formal motion to recuse, though, should have, the legislative requirements to follow motion to recuse. Yes.
What are the legislative requirements, to your knowledge, based on what you know about it? What are the legislative requirements for that motion to recuse?
I would have to look into it. I don't have the statute in front of me.
Okay. Have you ever filed a motion to recuse before?
Yes.
Okay. What do you know about as far as the grounds for the recusal? What would the ground be for the recusal in a situation like that? That the defendant just didn't like the fact that the judge was related to the prosecutor? What's the ground for that would be appropriate in a situation like this?
If I were to file if he would have requested for me to file a recusal, what I would have filed is a motion saying that the appearance that there's an inequality. I don't know exactly the statutory terminology, but that's what it would be. The appearance of inequality. Yes.
That's what you understand it to be, correct?
Correct.
And is this what you would have explained to Mr. Gross at the time?
Certainly.
All right.
I did explain that to him as it's contained in my affidavit.
Sure.
Mr. Gross wanted to go to trial come hell or high water, basically.
Sure. But here's the thing. The fact that, do you recognize as a criminal defense attorney at that point for Mr. Gross that this could be problematic? The fact that her son is going to be the prosecuting attorney in this case, and not only is she going to be presiding over this case, she will be deciding the punishment in the event that Mr. Gross is convicted. Do you ever think that in your mind at that point, Mr. Cargill?
Actually, you talking about in this particular case? No. I advised Mr. Gross of those dangers, but my experience with both Brian and Judge Evans and the Anderson County District Attorney's Office in general has been a fair handling of the cases. I've never had an instance in that case. In fact, many times Judge Evans had given my client's probation way beyond the objection of Miss Mitchell and Mr. Holden, but she's always been pretty fair on her judgment.
Okay.
This particular instance, though, I disagree. I think that the judgment was pretty harsh, but I think it had to do with his 2 pages of criminal history.
Well, but before we get to that point, though, okay, at some point, we don't know exactly when, but at some point prior, you're discussing this with Mr. Gross. You're not telling him, Mr. Gross, this could be a very serious problem in your case. You don't ever tell him that, right?
Well, yes, I tell him the potential, yes.
But you just testified that you believe that the relationship would have no bearing on the case, right?
I believe that, but I
Okay.
still would tell him the possibility that, you can do this. There is a possibility that this could be an issue.
Okay.
He
But
probably, if he would have asked, I don't know if he did, but if he would have asked, have you ever had a problem with Brian before? I would have said no, but I would certainly tell him the possibilities out there.
okay. You would agree as a lawyer that you have control over several aspects of the case. Would you agree with that? You decide what objections to make, which motions to file, things of that nature.
To a point.
Okay. So
If your client asks for certain motions to be filed and there's any legal basis at all, then you should file them, even if you disagree with the motion.
that's your position.
Yes, that's my position. Even to for instance, if a client asks you to file a motion to suppress and you say, well, I really don't see that, but there could be a possibility, you still file it. For instance, if your client says, I want you to file a motion to dismiss, and there's no reason to file a motion to dismiss, so there's no legal basis to file, then I would tell them there's no legal basis to file a motion to dismiss. I'm not filing one.
Okay. But in terms of the recusal goes, would you agree that Mr. Gross is relying upon your advice as his lawyer regarding that particular issue?
I'd say he partly relied on my advice regarding
Okay.
that issue. Yes.
And if you don't have any reason to doubt the impartiality of Judge Evans handling a case where her son is the prosecutor, you're going to convey that to him, right?
Yes, if he asks.
Do you discuss any other remedies or problems or issues, anything else like that related to this?
I don't understand the question. I'm sorry. Maybe
Okay, you mentioned, okay, we could file a motion and ask to have the judge recused. And you kind of partially state what the ground is. Is there any other basis for, are there any other constitutional or statutory rights that are at issue here that you're aware of?
Well, you don't necessarily have to file a motion to recuse. You can just ask the judge. And I can tell you, she probably had plenty of cases on the docket. She would have been happy to pass it on to another week and give it to another judge. That tended to be the reason why they started assigning cases to judges, because judges would pass them off to each other.
Okay.
The second thing is, if I thought that there was a big objection with Mr. Gross, or he had a big objection with Brian being on the case, I could have gone and told Allison, hey, Mr. Evans doesn't need to be on the case because Mr. Gross doesn't want him on there. He wasn't, the primary prosecutor or anything important to her anyway. She could have tried the case without him.
Okay.
But
Just a minute. Let me just interrupt here for just a second. Mr. Cargill?
yes, ma'am,
Were you finished with your answer or not quite?
I was finished.
Okay, sorry, I didn't mean to interrupt you. I did want to get you before the next question, though. Mr. Mayor, would you look at your notes and see if you can give me a realistic estimate? We are pretty deep into the time that you thought you would be finished.
I know, I'm at that 1 hour mark that I said I thought that would wrap up. I
Well,
see maybe
generous 1 hour.
Pardon?
The generous 1 hour. We didn't really start when you started.
Looking at my notes, Your Honor. Looks like I only have about 6 more items that I need to discuss with him.
And your rough time estimate?
I'd like to say 15 minutes, but I think it's probably going to be closer to 20 to 25 minutes.
All right, well, let's say that you're going to stop at 11:10.
Okay, thank you, Judge. All
Go
right.
ahead, please.
Okay, Mr. Cargill, let's talk about Brian Evans. Now, in your affidavit, you said that, look, all that Mr. Gross was concerned about was getting this case tried. He did not want to delay it, right?
Yes, sir.
Okay. It's your position that moving to recuse Judge Evans would have delayed that, right?
It could have delayed it.
Yeah.
Yes.
Okay. However, doing what you said, walking over to Miss Mitchell and asking her, hey, I don't think that Brian Evans should be on this case since she's the judge. You could have done that, and that would not have delayed the proceedings at all, right?
Correct.
Okay. And would you agree that if Brian Evans is removed from the equation, then it's a much different circumstance because he's not an advocate for the state prosecuting Mr. Gross, trying to secure his conviction and a lengthy prison sentence?
How do you mean it would have changed? I don't understand the question, apparently.
The trial could have proceeded without this problem of having the judge related to the son, related to the prosecutor as her son. You wouldn't have that problem if you would have simply asked him to be removed off of the case, right?
You would, well, if I asked Allison for him not to be in the case, she probably would say, no, he's not going to be in the case, or she could say, tough luck, take it up with the judge. I don't know what she would have said because I didn't ask her.
So let's go to that scenario. So you go to Judge Evans and you say, Judge Evans, I think you can be fair and impartial in this case, but I don't like the appearance that it creates that your son is the prosecuting attorney. I want you to order him to be removed from the case. If she agreed to do that and said, Brian, go to your room, I'm sending you out of here, the case could have still proceeded to trial with Miss Mitchell as the prosecutor, right?
It could have, yes.
I mean, she was the primary lead prosecutor. She did jury selection, opening statements, handled a bulk of the witnesses, right?
I think she handled all the witnesses except Brian, I think, did either cross-examination or direct examination of one of the state's witnesses. Yes.
Here's the point. At no point did you ever make an effort to have Brian Evans removed from the case, given his relationship with the judge. Fair to say?
Oh, yeah, that's fair to say.
And whether Mr. Gross wanted it or not, you as the lawyer could have said, we don't need to have this problem. And you could have made the motions and objections. You just chose not to in this case.
I could have if I had a belief that that was a problem.
And that's
I
what this is
honestly-
about, is that you did
All
not.
right,
believe-
excuse me just a minute, Mr. Mayor, please don't interrupt that answer. Go ahead, Mr. Cargill.
I did not have the belief that that was a problem. I had had experience with both Brian and Judge Evans, and I did not have a problem with that. And that's my personal belief.
Okay.
I did advise my client and tell him, and it was his choice to go on and his choice not to have a problem. In fact, I think I put it in my affidavit, and I think I remember, I'd have to look back at my affidavit, but as we're talking, it could have helped because Judge Evans might have acted more in our favor because her son was on the other side. You never know what's going to go on in a trial or what's behind the judge's thinking. But to be honest, no, I didn't think it was going to be a problem. I just didn't.
And you would have conveyed that to Mr. Gross.
If he asked, yes.
Do you recall conveying that to Mr. Gross?
Honestly, I don't, other than maybe I would have told him that Brian was Judge Evans' son, and that he would have, if he's in the case, do you mind if he's the prosecutor?
But if you don't see it as a problem, you're going to tell him, I don't see it as a problem.
If he asks me, yes, I'm going to tell him no. If he then asks the question, well, do you think that's a problem? I'm going to tell him no. I think that they're fair. Yes, that's what I would give. That's my personal opinion.
Now, let's talk about all of this discussion and everything that's going on. As the appellate attorney, that there is absolutely nothing in the reporter's record reflecting that Mr. Gross was made aware of the relationship between Judge Evans and Brian Evans. Is that correct?
After I received the record, yes, I did. Honestly, I thought it was discussed on the record. I believe that it was discussed in open court, but I think that she gave that disclosure every time. And she gives further disclosures. If Judge Evans is to the point on conflicts, if she says, oh, I used to work for whatever defense, I think it's Potts defense firm, and this one person used to be a plaintiff, she'll make that disclosure. And most of the time everybody goes, okay, let's go on. Let's go forward. But yes, I think it was probably made, but
okay.
I
Let me ask
don't have any court reporter record of it.
So let me ask you this. When you get the record in this case, just shortly after the conviction, when you're working on the appeal, you're reviewing the record and you're placed on notice right then and there that, wait a second, there is nothing here in the record to reflect that Mr. Gross was made aware of this, right?
Correct.
Okay. Did you make any efforts at that time to locate with the prosecutor whether or not, or not the prosecutor, I'm sorry. Did you make any attempts to discuss that with the official court reporter to determine whether or not there was in fact a recording of that issue?
I didn't until this writ was filed.
Okay. Because again, you didn't see it as an issue at the time. Is that fair to say?
That is fair to say.
And are you familiar with the bystanders bill?
No, not really. Not with that name. No.
But again, you're not seeing as an issue, you don't make any efforts to confirm that there is some record to show this, right?
Correct. Because in my own mind, I had that discussion with Mr. Gross. Mr. Gross didn't have an issue with it. Mr. Gross didn't. I asked for Mr. Gross to have another appellate attorney. He didn't want another appellate attorney. He wanted me. He didn't have that as, he still didn't have that as an issue. Never brought up the issue, the fact that Brian was, a prosecutor in the case. Never brought up any of that issue.
Well,
The issues that he brought up is he thought the officer lied, that, all kinds of other issues.
Well-
That was never a problem to him at all. And still has never been a problem until this writ was filed.
so let me ask you this then, Mr. Cargill. Are you saying that it's up to the client to tell you what the issues are in a particular case?
In some instances, yes.
That's what you feel your duties are as a lawyer and as an appellate counsel, that it's the client who should tell you who the issues are? Or what?
Yes. If you're going to proceed on an issue where a client would have a personal objection that's not necessarily, that may have a legal basis, but it takes a client's belief. I'm not going to tell a client, oh, you need to believe this so I can file this.
But
I'm not going to do that.
I'm not talking about beliefs. I'm talking about legal
Hold on
issues.
just a minute. I'm not sure we're getting all of Mr. Cargill's testimony.
Again, I'll repeat, I am not going to tell a client, if you believe this, if you will believe this, or if you tell me, hey, I believe this, then I can file this. I'm not going to lead a client to that point. If I'm discussing a client and the client says, well, I really believe this, then I'm going to, or making whatever proper objection. But I am not going to conform my client's belief just because I think, oh, there may be this legal out if they believe this or they did that. I'm not changing their testimony and I'm not changing their beliefs.
But here's the question or the problem that I'm trying to address, Mr. Cargill. If you don't tell the client that there is a legal issue, that there's something that may be in violation of the law, if you don't communicate that to the client, you can't expect the client to know that it is a legal issue, right?
Correct.
So just so we're clear, you never thought that there was an issue with the relationship between the judge and the prosecutor. And so Mr. Gross never had any reason at that time to suspect that this could be a problem for him in his case, right?
Well, he was aware that that relationship existed.
But
He was, if I could finish, he is aware of who the judge was. He is aware, of all those factual instances. I don't know whether I gave him the opinion, but if he would have asked the opinion, do I think that Brian Evans and Judge Evans are fair? I would have said, yes, I do believe they're fair. If you asked me today, I would say that I believe they're fair. Yes.
But the bottom line is if it's not an issue to you, there's no way that you could expect him to make it an issue, right?
Oh, yes, there is a way. For instance, I wouldn't have done the case like he requested to do. I would have waited and continued the case on, but he wanted to get the case done immediately.
Okay.
And that's one instances. But there are other instances, even in the actual trying of a case, that not only Mr. Gross, but any client is going to tell you, well, I want you to put this person on the stand. If they really want you to put that person on the stand, you put the person on the stand, even though you may not want to. Sometimes you even make a record. I'm telling my client, don't put this person on the stand, but they're telling me to put this person on the stand. There's other instances that Mr. Gross directed me in his representation that I might not have agreed with, but I still do what the client says. After I advise the client, it is his decision on what to do and how to proceed on his. what Mr. Gross's thinking was. He might have thought in the back of his mind, if we objected and it got overruled, that the judge may be mad. I don't know. He never discussed that with me. But everything that I would think that Mr. Gross would do would be speculation. All I know is what actually happened.
Your Honor, did you and Ms. Waldrop get that response? It was a little bit lagged, but I was kind of able to make everything out.
I can't speak for Ms. Waldrop. I was able to understand it. Ms. Waldrop?
Yes, it's Patricia Schultz. I worked with Susan.
Okay.
It was hard for me to get down. I wrote down what I could
Okay.
I'm satisfied with that.
clarify.
All right. All right. Then next question, Mr.
Thank you.
Mayor.
Okay, let's move on and let's just talk about the appellate issues in this case. Preserving error, Mr. Cargill, what does that mean to preserve error in your mind?
It depends on what you're talking about. It could be that you're preserving error by making an objection in the actual trial of a case. It could be preserving error if you tell the judge you want to introduce certain evidence and they don't want you to introduce the evidence. You can make another report of what the evidence should be. Preserving error could be if you're asking for a motion for continuance because you couldn't find a particular witness and it's denied, then you put in what the witness may or may not be able to present. There's all kinds of preserving error for appeal purposes.
Okay. So now that we know that you have an understanding of that, is it safe to say that you knew that in the event that Mr. Gross was convicted, that in all likelihood, you were going to be kept on as the attorney on appeal? Was that did you kind of consider that as a possibility at that point?
Yes, it was a possibility.
Okay.
Usually Judge Evans assigns someone else, but yes.
But you have been appointed to represent people that you've been appointed on appeal to represent people that you also were appointed to represent at trial on numerous occasions prior to Mr. Gross's case, correct?
Yes. Usually what happens is they ask, do you want another attorney to do the appeal or do you want the same attorney? And the defendant responds. Here lately, they haven't been asking. They just go ahead and appoint somebody else because they actually don't appoint. The wheel points them now.
So having talked about preserving error and understanding that you're going to potentially be handling the appeal, you understand that you have to object to something in order to be able to complain about it on appeal, right?
That's correct.
Okay. You understand how courts will routinely say you waived any error because there wasn't a proper objection, right?
That's correct.
Okay. At this trial and at sentencing, okay, you knew from previous cases that you have handled and that have been made part of this record, you knew that complaining on appeal about any inequalities or constitutional deficiencies with the sentence could not be raised on appeal if you did not object to it at trial. You knew that prior to this trial, correct?
Hold on, I'm sorry.
That's okay.
Not all objections have to be preserved in regards to inequalities for the sentencing. If the sentencing is grossly disproportionate and it's cruel and unusual punishment, you wouldn't know that until the sentencing took place.
But
Yes,
you would have to make it.
I'm
sorry.
aware of objecting to preserve error. Yes.
And even though, okay, and when you were representing Mr. Gross at trial, once the sentence was handed down, you did not make any objection at that time about any gross disproportionate sentence being handed down. You did not make that objection, right?
That's correct. I don't think I did.
And that's the only issue you raised on appeal.
I guess so. I don't have the appeal in front of me, but yes.
Well, you have to know because you raised that same issue in countless other appeals that you were appointed to represent, correct?
I have. I like that appellate point. And yes, I've used it.
Okay. And yet every time the court tells you, Mr. Cargill, error was not preserved, right?
No, actually, there's been several times that they have, one time they reformed the judgment of Judge Calhoun in Houston County, and other times they have overruled the and found in our favor. And I think that was only one time, and I'd have to look back and tell you when that is. But then the state appealed it. I think it was Scott appealed it to the Court of Criminal Appeals, and then they remanded it back to the 12th Court of Appeals. 12th Court of Appeals changed their mind, and it was affirmed.
On this exact same issue that you raised in his case?
Yes, on this exact same issue that I raised on this case.
If you don't believe that there is an appellate error, okay, or that it wasn't properly preserved, or if there's no error in the case, what can you do?
You can do a couple of things. You can ask for the client to either not pursue their appeal. You can file an Anders brief. You can also ask for some other person to be appointed and ask for them to file an appeal for ineffective assistance.
Did you ever consider filing an Anders brief in this case?
I asked my client whether or not I asked him whether or not he wanted me not to file an appeal at all. And that answer was no. As far as Anders brief, no, I don't believe I did. I don't think I've considered that. I have before, but I didn't in this case.
And as far as any records regarding this discussion, it would have been by letter back and forth between Mr. Gross while he was in custody?
No, sir.
All right, we're missing you now, Mr. Cargill. Hang on just a minute.
It would probably have either been by, well, could have. I'm sorry.
Okay, we missed really your entire answer.
Judge, okay, if he could repeat the question, I apologize.
My question was regarding the letters, the communication regarding the appeal with Mr. Gross. Would that have been via letters, or how would that have been?
Yes, likely letters.
Okay, but of course we don't have those letters since the file has been destroyed.
That's correct, but Mr. Gross should have the letters.
Okay.
If he kept them.
If he kept them. You obviously didn't, right?
I didn't keep them past May of 2020.
Okay. Last question, Mr. Cargill, is as an appellate attorney and having filed applications of writ of habeas corpus, okay, would you acknowledge that the appearance, okay, of what took place in this case, the fact that you have a prosecutor who is related to the judge, the prosecutor who has a person's liberty in their hands, would you agree that just the mere appearance of it does not look good?
No, not necessarily, but, and I that's just my personal opinion.
Okay. But ultimately, that's a legal decision that the judge is going to have to make, correct?
Yes, that is. That is.
If I can just have one moment, Your Honor, to confer with my co-counsel, and I think I'll be ready to pass the witness.
All right, thank you.
Thank you, Your Honor. At this time, I'll pass the witness.
All right, Mr. Holden, you've had a moment at least to think about it. Do you have any questions for Mr. Cargill?
Yes, I do, Your Honor. I hate to ask this, may we have like a 5 or 10 minute comfort break?
You may. And I was going to say that if you were not going to have any questions, it was going to be a different answer about what we were going to do next. Let's go ahead and take a break. It's 11:09. Would everyone please be back in front of their Zoom camera at 11:20? Mr. Cargill, obviously you're not discussing your testimony with anyone. And I'm going to mute everybody on the screen. So I will look forward to seeing you all at 11:20. Thank you.
Thank you.
I muted all of you, but it doesn't appear that I can unmute all of you. So we're not going to start yet until everyone is back, but I did want to give you all an opportunity to unmute yourself. It does appear Mr. Cargill is not on the meeting. There's Mr. Coe. Mr. Coe, we're going to need Mr. Cargill back if you have a way to contact him.
Let me get that done, Judge.
All right, thank you.
He says he's in the waiting room and got kicked off Zoom.
Well, I'll just say I didn't kick him off, but that's certainly not the first time. If he'll try to join the meeting again, I'll be sure to let him in the meeting room. He's not pending right now in the waiting room.
I told him to try again. His connection was pretty poor, so that might have been what got him disconnected.
It was, and I believe somebody said in an email that Mr. Cargill was on vacation. So he's very nice to have accommodated the court with scheduling, given that he was on vacation and could certainly have relied on a vacation letter.
Yes, Your Honor. I'm trying his phone.
Thank you.
He's trying again, Judge. It said something about, it gave him a message that the host was conducting a meeting and wouldn't, but I told him to try again and we'll see if it pops up.
The host is waiting for him.
Yes.
In fact, I'm checking. I don't have the meeting locked at all. You have to get in the waiting room to be admitted, but I don't have the meeting locked. So he would get that message. I don't know what's going on with that.
He's sending me a text right now, Judge.
All right.
He's saying she has to let me in, but it's not popping up. It's not giving you the option to let him in because it doesn't appear he's connecting.
That's right. Let me see.
Can we try re-inviting him to his mobile number?
Yes, I was just going to ask for that, but I don't know. I just sent out the invitation, so I don't have an email or a phone number to use.
Why don't, let me see if I've got the information here. Jeff, in the upper left-hand corner is that little green shield. If you click on that, it gives you the meeting ID and it looks like it just gives a meeting ID. Could you just send him to that and see if he can just log in using that meeting ID number?
Yeah, I'll try that.
If he goes to his Zoom, he should be able to enter the meeting ID to get in.
Right.
And if you all will excuse me, the one thing I forgot to do is turn down the heat. If you'll excuse me just a moment, I'll be right back. Don't start without me.
Hey, Brent, is that 8914 or 8014?
1 second. Let's see. That is,
It's 8014.
yes, 8014.
It's 927-8014-9460.
These are like our new telephone numbers. I give out my meeting ID number now, I give out my mobile number to people. So,
I usually send an invitation so you can just click on the invitation. But it's, I don't know. Wait, I have someone invited. Thank you. Thank you, Mr. Coe.
Yes, Your Honor.
Great, there it is.
Welcome back, Ms. Oh, he's not on audio yet. Welcome back, Mr. Cargill. You'll need to unmute yourself when you start offering testimony. This is, we're resuming cause number 32004-A, ex parte Richard Gross, counsel for the applicant, counsel for the state, counsel for Mr. Coe, and sorry, counsel Mr. Coe for Mr. Cargill are present. The witness, Mr. Cargill, is present. Mr. Gross, who is the applicant, also present. The court reporter is present. So I think we are ready to go. Mr. Mayor just passed the witness to Mr. Holden. Mr. Holden, on behalf of the state.
Thank you, Your Honor. Morning, Mr. Cargill.
Hello.
There's a lot of questions. One of the questions that has been discussed right now is how the courts are set up quickly in Anderson County. So I believe you're trying to explain every week there's a different judge for trial.
That's correct.
And those are pretty much set in stone, correct?
Yes, sir.
So if I asked you whose trial week is the first Monday?
Then you would go to that judge, and that's the judge that would be set for that week.
So
It
the first
goes-
Monday in Anderson County is?
I believe it's Judge Fletcher. I don't have my notebook in front of me. We actually have a notebook, and it's put on the county court dockets as far as CPS. He has that every Thursday. It shows which trials are going to be Judge Johnson for every month of the year, and then each court as they're put in there. We have a little chart, and that's set up by the court coordinator, and it stays the same every year.
The second Monday every month is always Judge Evans, correct?
Right.
And there was
And
some
then the
discussion.
third is Judge Davis, and then Judge Calhoun.
And there was some discussions whether or not your client would have known that Judge Evans was going to be the judge in this case, correct? There was a question asked.
Yes.
Now, there is a court reporter's record of that hearing of June 19th. Judge, have you seen that?
No, no.
And so, and forgive me, Your Honor, I'm not sure if all of the court reporter's records have been made part of the record of this court, but we'd ask that the court take judicial notice of this record.
This court does not have the reporter's record.
Nor do we.
Well, then we'd offer the court reporter's record into evidence by Mr. McAdams for trial court cause numbers 31833 and 32004 of State versus Richard Gross into evidence as Respondent's Exhibit 1. And I'll share that screen.
So, Mr. Mayor, I know you don't have it.
We have absolutely.
Opportunity to review it.
No, look, let's just get it in. I mean, we tried, just so I want the record to be clear. I mean, we did ask Ms. McAdams for all records. She informed us that she did not have this particular proceeding. But if she does and she's provided to the state, we have no problem with it being admitted into evidence at this time, so that we can all take a look at it and the courts can see it.
Okay. Well, there's no objection. Did you call it Respondents 1?
Yes, Your Honor.
All right, Respondents 1 is admitted. Now, we're all going to need a copy of it, Mr. Holden, and you're going to have to take that up with the court reporter.
Yes, Your Honor.
Of course, you'll be giving her back the Respondents 1, but we're all going to need to get copies, I guess, from the district clerk, as it'll be an exhibit of Respondents 1, because I don't have a copy of any of the record. And apparently Mr. Mayor doesn't have a copy of this hearing. So with that, you may go ahead. You have it on the screen. You want to publish Respondents 1?
Yes, Your Honor.
All right, you may.
And I'm sorry, Your Honor, I should have asked first. My apologies. It's the computer is throwing me off. My apologies, Your Honor.
It throws us off.
I'm going to go down to page 6. I believe. Yes. Page 6. It's after discussion of a trial amendment. Later on, it says from the court, okay, Judge Evans is next Friday, the 26th. So if I set it on for her trial docket on July 13th, it would announce ready next Friday. Answered by Mr. Cargill on line 7. That's fine. So it was discussed in open court that Judge Evans would be the one trying this case on the July 13th date. Correct, Mr. Cargill?
Yes, yes, sir.
And let me get this, how to stop sharing. Where is it? Well,
You should have a little bar up at the top. Sometimes it's green that lets you stop sharing.
it was on a different screen. I'm sorry.
Okay.
There we go. So there was a talk about, at least at that hearing on that date, that this case was going to be set in front of Judge Evans.
Yes, sir.
And you discussed this later with your client, is that correct?
Yes, sir.
In per your affidavit, he wanted to go forward even after you discussed the fact that Brian Evans was her son.
Yes, sir.
Matter of fact, in your affidavit, he told you he thought it would be more helpful to him trying to get probation.
That's how I remember. Yes.
In fact, in your affidavit, he was focused on getting probation the entire time through your dealings with him.
Yes, sir. And I explained to him that, the possibility of that was nil or next to nil, especially after the state filed their enhancements, which was real late. It was just right before trial, if I remember that correctly. The enhancements were filed just prior. They weren't part of the indictment.
And you explained to him that's going to be very remote. Is that correct?
Yes, sir.
But he persisted in going forward?
Yes, sir.
Now,
if I remember right, and I think I do, he was even vocal at court saying out loud he was going to go forward and that he wanted to have a trial. He was ready to get out of jail.
and there was a question asked about a plea offer. And you discussed that there was a plea offer given?
There was.
And do you recall what the plea offer sheets look like?
Yes, they're a piece of paper, and we get the white copy. Y'all have the yellow copy. I initial or sign where I received it, and usually put the date that I receive it, and take that. And I usually immediately just go over and walk and give it to my client so that they can know what the copy is. Sometimes I talk to them after a day or after that I receive it.
And forgive me, Your Honor, now, this is a document I wouldn't think I would have had to have entered, but we would want to offer it, but I can't show it to him unless I share screens. I have a copy of the plea offer recommendation of the state of Texas from our file.
Is there going to be any objection to that, Mr. Mayor? You're muted.
No objection, Your Honor.
All right. So are you going to offer respondents two?
Yes, Your Honor.
Okay. Respondents two is admitted without objection. You may publish it.
Thank you, Your Honor. And Mr. Cargill, are you seeing what's the state's recommendation on felony?
Yes, sir. It's 9 years.
And at the bottom of the page, Is that your squiggle mark at the bottom?
It is.
And the date next to, is that the date you received this offer?
Yes, sir.
And at any time, do you recall, did the plea offer ever change from the state of Texas from 9 years?
Yes, it does change when that's 9 years as a third. When y'all file the enhancements, y'all wouldn't have offered 9 years because the minimum would have been 25. But usually y'all don't, if we get that far along, y'all say we're pulling the offer. But I don't remember in this particular instance way back then, no. But generally, it's y'all's position if we don't accept it at status, unless there's some big change in the case, y'all, it's tough luck. And that's what the judges explain at status.
Now, the day of trial, do you recall whether or not there was a discussion of the fact that Judge Evans and her son again was going to be involved in the trial?
I remember it that way, yes.
And did you discuss that with your client
I did.
again?
Again.
Did he waive that?
He had no objection, no problem. He wanted to go forward. That's all he kept. Well, he was asphyxiated with wanting to go forward as soon as possible.
Now, to be fair, there's nothing in the court reporter's record that shows that, but to your recollection, did that happen?
Yes, sir. And it would have happened back in the jury room. We quite often, that's where we'll get to go back if we want to discuss something with her client. We would have been by ourselves.
Now we get to a part of your affidavit you were asked questions about, particularly in regards to the destruction of your file and
Yes.
when you knew about all the things going on with Mr. Moore. When did you discover that information?
When I got contacted that he had filed a writ and I needed to do an affidavit.
So when did you discover all this information about the market?
Well, after I got notice I had to do a affidavit, I went to the first floor of the courthouse to where you can use the computer to find records. I looked at the clerk's record on the file, and that's where I discovered that he had asked for the PSI back then, and then also the letter that was sent to the court.
So in other words, when you're saying in May 9th, he asked for the release of the PSI, February 16th, you discovered all of those when you looked at the clerk's record after you got notice of this writ?
Yes, sir.
After the time when you would normally destroy your files?
Yes, sir. I think if I would have had my files, it'd be advantageous for my defense.
Now, as a defense attorney, and I know I don't have a lot of experience in that because I'm a prosecutor, but are you allowed to place your personal choices over the defendant?
No.
So for example, I think you were using this, if your defendant insisted you called a witness that you knew as soon as they took the stand would sink your case, and they were insistent upon it, you used to have to call that witness.
I would.
Furthermore, as an attorney, you have an obligation of candor to the court.
I do.
And your knowledge at the time of this trial, the defendant waived his any objection to Mr. Evans being the attorney for the state.
That's
or
correct.
working for the. And if you'd filed a brief raising that as an issue, would that not violate your duty as to candor to the court, even though it doesn't appear on the record?
Correct.
So that would be an issue you couldn't raise on appeal.
No, because he didn't ask to object to that. He had no objection to that.
Now, were there any significant objections that you recall at trial that went against you? From
No.
Judge Evans?
No. And I review the record again and again to see if there's anything. And I reviewed the record summarily. I didn't detail it, but I reviewed the record summarily again. And I don't believe there's any error in there. It's a clean trial.
Now, what about any issues as to mitigation? Didn't his PSI show some reports of mental health issues?
They did. He didn't discuss any mental health issues. And when I got the PSI, that's when my understanding about the mental health issues, but he didn't want to bring up even the mitigation of intoxication. When we talked about it before, he was willing to do it. But once he got arrested and put in jail because he was intoxicated or he had drugs in his system, he did not want to discuss that as part of presenting evidence. And I tried to explain to him that could be a mitigating circumstance, but he did not want to do that. Then he reluctantly agreed to do it. And also in regards to the mental, he reluctantly agreed to it. But me having any mental records, I didn't have any.
In fact, he wouldn't give you the names of any of his doctors?
Excuse me, Mr. Holden, before you go on, I know you said you didn't have the benefit of the amended application. This ground has been abandoned regarding an investigation into mental health. If you want to pursue it for some reason, you're subject to objection and a ruling, you may, but it has been abandoned by the applicant.
And I was
I'll move
just,
on.
okay, and I was just going to lodge an objection, but I think we're clear on that. Okay, thank you, Your Honor.
One moment, Your Honor. I'm sorry, I'm trying to locate something.
That's right. Mr. Mayor, how was I'm just curious, how was the amended application served on the state?
I emailed both an unsworn version of the application to them while we were waiting for Mr. Gross to sign it. We sent that to them months ago, and then once we received the actual signed version from Mr. Gross, we also forwarded that via email as well.
Okay, well, I know it was filed with the clerk because I received a copy of it.
You know what? Actually, Your Honor, I think I may have it only may have been served on them via e-serve through my electronic filing manager is how it was served to them.
Okay, well, Mr. Holden's probably ready with this next question now, but I was just curious. Go ahead, Mr. Holden.
And for the record, that is how we received it, and I had it ahead. I've got the two confused in my mind just now. I'm sorry, Your Honor. Now, you were asked lots of questions about recusal and disqualification. Are you aware whether or not you could have disqualified Judge Evans?
I didn't hear the question.
Are
Sorry.
you aware whether or not you could legally disqualify Judge Evans?
Yes.
For disqualification, is it true that they would have to be a party to the case or have a pecuniary issue related to a party?
That's correct. You could also, that's the disqualification. You could ask her to be recused or ask her to step down if you say, oh, well, I think that it's unfair, or we have a feeling that it's showing that it's unfair, but that's not a legal disqualification.
It's a difference. There's a difference in the law between a disqualification versus a recusal, correct?
Correct.
So, and Did
If
Judge Evans have a pecuniary interest in this case?
No,
Was she related to any party in this case?
no,
Are the attorneys involved in a case a party to the lawsuit?
no,
So the only issue would be the disqualification issue,
right.
and that would be something that would be waivable, correct?
That's correct. And in my own experience, that's waived quite frequently, a disqualification, not necessarily this disqualification, but quite a few
Well-
times qualifications waived.
Or grounds for recusal, in other words.
Right.
And you brought up that there are we're a small jurisdiction, is that correct?
Correct.
Not like Houston or Dallas.
Correct.
Historically, Judge Calhoun Sr. Had his son sometimes appear before him, who's now Judge Calhoun, Mark Calhoun.
That's correct.
And I believe there was the same issue with Judge Lawrence and his son, Martin Lawrence.
That's correct. And Melvin and Stuart Whitaker.
So it's not an unusual occurrence in a smaller jurisdiction to have this come up.
No, it's not unusual.
And furthermore, the punishment rate of this hearing, was Mr. Evans involved in the punishment hearing?
No, Brian? No.
It was just Miss Mitchell.
Yes, sir.
And that punishment hearing happened many months after the trial.
It did because we were asked for a PSI.
Do you recall why he was placed into, Mr. Gross was placed into custody prior to trial?
I believe it's failure to appear, but Judge Fletcher usually drug tests people as well, but I believe this was for failure to appear. I don't have it in front of me, but it was a violation of a bond condition. Bond.
Okay,
That's,
I'm going to object relevance and non-responsive. I'm going to object to that response. And it's, I don't know whether it's clear whether it was a failure to appear or bond condition. Again, I don't think any of it's relevant to any of the issues here. So I'm going to object on that grounds.
All right. That's overruled. Of course, the only person entitled to a non-responsive objection is the person asking the question. And I think that's really the nature of your objection.
Okay.
All right. Mr. Holden?
thank you, Your Honor. So it's fair to say after a failure to appear, chances of getting another bond from the judges in this county tends to be rather remote.
I'll put it at 0, but it probably could happen.
So the only way your client, Mr. Gross, was going to get out of jail, if at all, was going to be at a trial.
Yes, sir.
Is that
Or-
why he's?
Or y'all dismiss it, which wasn't going to happen either.
Is that why he was insistent on going to trial as soon as possible?
Yes, sir. He did not like jail.
And when the case was called and would have gone before trial in Judge Fletcher's court, the next time for Judge Fletcher to have been able to hear that case would have been an entire month. Is that correct?
Yes, and that's only if she didn't have another one scheduled that was set prior to Mr. Gross being set for that setting.
All right, I think I'm about done. I hate to ask this, but may I have a brief moment to confer with co-counsel before I determine if I'm going to pass?
You all want to go in a room, or are you able to get in a room there?
We're able, can walk out the door and talk to her.
Okay.
Thank you, Your Honor. I'll mute myself.
He's coming, Your Honor.
All right. No hurry. Thank you.
Thank you, Your Honor, for that brief moment. You pass the witness.
All right, Mr. Mayor.
Just briefly, Your Honor. Mr. Cargill, in your affidavit, you maintain that you are a competent trial and appellate attorney with a good, you said representation, but you meant a good reputation as someone who fights for his clients. You recall stating that in your affidavit?
Yes, sir.
Do you believe that?
I believe that.
You would agree that if a court were to find you ineffective or to find that you did something contrary to your client's best interest, that would seriously call that reputation into question, right?
No, I don't think so.
Okay.
That would be that that would be the court saying, "Hey, you made a mistake." Everyone makes mistakes, but
So
I think maintain the same reputation.
So are you saying that you don't feel like you need to defend yourself against these allegations that are being made against you?
What I need to defend is what is true.
Okay.
I'm different than a lot of defense attorneys. I believe in defending what is true and what is the law. And I believe that every defendant is entitled to a defense based on the law and truth. I'm not going to make up facts. I'm not going to try to sugarcoat things or anything to that effect. So, yes, that's how
But you would agree that in all, but would you agree that it,
defending myself, as far as defending myself, yes, I'm defending what I believe is the truth and the right.
but as far as the law goes, you advise people based on the law as you know it, correct?
Yes.
I want to talk briefly, just quickly about punishment. Again, we had a lot of discussion about Mr. Gross wanting to go to trial and wanting to get probation, right?
Correct.
And we talked about how you explained to him that the only person who could give you probation is the judge, and that is why, in large part, why he elected to have the judge decide his punishment, correct?
Correct.
When it came to the punishment phase, you also told him that he could not get probation if the judge found the enhancement paragraphs to be true, correct?
Once those enhancement paragraphs were filed, I explained that, yes.
Okay. And the one thing he was adamant about is he wanted to be out on probation, correct?
No, actually, he was adamant that he wanted to be out,
Okay.
whether it was by bond or by dismissal or probation.
After he was convicted by the jury, the only way he was going to get out of custody is if Judge Evans granted him probation, correct?
Yes.
And the only way she could do that is if she did not find that he was previously convicted twice of being a felon, right?
Yes. If she didn't believe or find both of the enhancements.
And yet,
Or at the time when I first advised him, the enhancements had not been filed. But go ahead.
and yet at trial, despite knowing all of that, Mr. Gross, on your advice, pleaded true to those allegations, correct?
After I showed him the judgments and he looked at them, and they had their witness to prove up the fingerprints sitting on the second row And he asked, well, what would they do? And I told him, yes. He said, well, then I'm going to plead true. And so we pled true. We could have fought them. We do quite often. But if the fingerprints analysis is going to show, they're going to show. And they had the proper predicate to show those.
And what you're saying is that, and so by having him do that, you effectively eliminated his one chance of getting out, correct?
What I did is by having him do that, in our belief is that if you're already that far into the position, you don't want to further inflame the judge. If you're not going to get probation, then you want as least amount of time as possible in jail. Yes.
But you're removing it as an option by pleading true. Would you agree with that?
I'd agree with that. Yes.
Mr. Cargill, last question. Would you agree that just because something is common and done often, that doesn't equate with it being legal and in compliance with the law?
For some instances, yes, I'd agree with that.
I said that was my last question. This is actually my last line. Mr. Holden pointed out for you in that the record of the proceedings from June 19th, that there was a discussion that Judge Evans was going to be presiding over the case, correct?
Correct.
Judge Evans presiding over the case is not the issue. Do you understand that as what's being alleged here?
I guess I didn't see the second amended writ, but yes.
Well, here's the whole point is Judge Evans presiding over the case is not the problem. It's Brian Evans sitting there at counsel table as an advocate for the state, prosecuting him. That's the issue in this case, correct?
That's the issue that you're bringing up. Yeah.
Are you familiar with the Supreme Court decision, Williams versus Pennsylvania, that came out in 2016?
No.
I'm gonna read you something and I'm gonna ask you a question about this. Judge Kennedy, writing for the majority, said, no attorney is more integral to the accusatory process than a prosecutor who participates in a major adversary decision. Do you agree with that statement or disagree with that statement?
It can be. I guess I partly agree, partly disagree.
Would you agree that even though the attorney for the state is technically not a party to the litigation, an attorney for the state has an incredible amount of control over an individual's liberty, particularly a criminal defendant's liberty?
I think each participant in a trial has control over the defendant's liberty. The defendant's attorney, the prosecuting attorney, and the judge.
You can't dismiss the case, right?
Not unless it's some legal reason, 180 days without filing an indictment or some other instance, but I'm sure you're aware of those.
Sure. The one person who has the most control over that decision is the prosecutor, correct?
The dismissal, yes, it would be the prosecutor.
And they have control over the offers in the case, right?
They do.
In this case, prior to trial, Mr. Gross,
Actually, the judge also has control over the offers, because many times our judges won't accept an offer if they don't like what the state offers.
But it begins with the prosecution, right?
Yes, sir.
And the prosecutors in this case recommended 9 years prior to trial, right?
Well, they offered 9 years prior to the status. At the status, that's when we have to decide whether or not we accept the offer or go to trial.
But again, at some point, the state, prior to that trial starting in July of 2015, offered to recommend 9 years if he were to plead guilty, correct?
That's correct.
And instead, he went to trial before Judge Evans with her son as the prosecutor, and he was sentenced to 60 years, correct?
That's correct.
And Brian Evans is now the elected county attorney in Freestone County. Is that right?
Yes.
No further questions, Your Honor.
Mr. Holden?
So, going back to the very beginning, about the pleading true or not to the enhancements, did you remove the option or did your client make the choice of removing the option of fighting those enhancements?
My client chose the option to plead true. I don't make those type of choices. I give the client all the alternatives and he makes the decision.
In fact, in your opinion, is sometimes fighting those just makes, it can incense the court even further, correct?
Correct. And in
And-
fact, this particular judge, you can look many times on the record, she says, I'm going to give the defendant less time because they admitted this or that. And just recently, she gave a defendant way lower than what the state was asking because they admitted to something.
And there were a lot of questions about Brian Evans being the problem in this case. Was Brian Evans the lead prosecutor?
No,
Did he indict the case, to your knowledge?
no,
Did he make the offers?
no,
He only had one witness, is that correct?
that's correct.
Was it a major witness or a minor witness?
Minor,
The rest of it was directed by the lead prosecutor, is that correct?
correct,
That lead prosecutor was Allison Mitchell, is that correct?
correct.
Allison Mitchell, the elected district attorney of Anderson County.
That's correct.
So who has the control of where this case is going? An assistant DA or the elected who's prosecuting the case?
It's always Allison's control. We don't like what you guys offered us. We can always try to go up to Allison. She
Yeah,
can.
and I've got footprints on my head sometimes.
Yes.
So is there any doubt in your mind who was running the show in that trial? Is Allison Mitchell?
Yes, sir. It's Allison.
And a jury is the one who found the defendant guilty, correct? Not the judge.
Correct.
She may have sentenced, but it was the judge the jury of 12 people in Anderson County that made the decision that your client was guilty of this assault on a public servant. Mr. Gross.
Yes.
Passing this.
Mayor?
Judge, I have no further questions. I'd just like to state for the record and for to Mr. Cargill that I know we said this was mentioned off the record, but Mr. Cargill, we do appreciate you taking time out of your vacation to appear and testify in this matter. I don't want you to think that we took this decision lightly, and I don't want you to think that we are very grateful and understand that the sacrifice that you made to appear here today. And on behalf of Mr. Gross, we do want to thank you for making that accommodation for us. That's all I have, Your Honor.
Mr. Cargill, in fact, you weren't present because we were having our phone difficulties, but I did say you easily could have relied on a vacation letter and had to reschedule this hearing, but I appreciate you going forward, as I'm sure everyone does. Mr. Coe, is there anything else from you? If not, I want to excuse you and Mr. Cargill.
There's not, Your Honor.
All right. I can put you out or you can just turn off your devices.
I'll leave, Judge.
And thanks to Mr. Coe as well for his help and his
Absolutely.
cooperation. He's been very
Glad to
helpful, Your
assist.
Honor. So,
Thank you, gentlemen. You're welcome to excuse yourselves. And there they go. All right. Mr. Mayor, any other witnesses?
Judge, other than the evidence, the exhibits that we've admitted and the testimony from Mr. Cargill, we have nothing further to offer, so the applicant would rest.
All right. The applicant is rested. Either Ms. Mitchell or Mr. Holden, any evidence on behalf of the state?
Ms. Mitchell wants me to
You want to
follow
talk-
from.
Yes, you all may have a conference, however, whatever hocus pocus it is you're using to do that.
Judge, just
Sure.
call me, Scott, call me right quick.
Yes, ma'am.
All right, then either Mr. Holden or Ms. Mitchell.
Yes, sure. Actually, I have a question before. Is Mr. Gross's affidavit part of the exhibits that were offered?
Uh,
It is, Your Honor. I'll answer that question very quickly. It was admitted as exhibit number 64. Let me confirm that. 64 that was admitted is his affidavit.
Okay, I read all of the affidavits, or excuse me, all of the exhibits one afternoon, but I didn't specifically remember seeing his, but now that you mention it, I do remember that. So anything else, Mr. Holden?
Just that we didn't have a chance to be able to cross-examine that witness on their affidavit, so we asked that be taken into consideration by the court, and we have no further evidence to present.
All right, then. Just a little bit about arrangements. I did ask Ms. Singletary to contact TDCJ, specifically the WIN unit, about any arrangements that needed to be made for Mr. Gross's lunch. And quite frankly, the response was no. So anyway, I don't want to abuse you, Mr. Gross, but if anyone wants to make a closing argument, I think this would be a good time, and let's limit it so we don't, again, I did ask about lunch from Mr. Gross, and I didn't receive a response that was meaningful to my question or to the proceeding. So, Mr. Mayor, on behalf of the applicant, if you could limit your comments to maybe 10 minutes.
Oh, Judge, I think I can limit it to maybe like 3. First and foremost, we greatly, on behalf of Mr. Gross, we greatly appreciate the consideration that you've given in this case. We know that this is not an easy call to make in this case. You have an affidavit from Mr. Gross. This was the only thing on his mind at that time, and this is the only thing he's had to think about since he's been locked up since June of 2015. And his affidavit makes it very clear that there was never any discussion regarding the relationship between Mr. Evans and Judge Evans. But on the other hand, you have Mr. Cargill's testimony. And, I know that's a difficult position to make a call on this, but I do want to say that this whole situation just stinks, Your Honor. It stinks that there's no record of this discussion. There's no record of a waiver on the record. There's no notes of the discussion because Mr. Cargill just coincidentally happened to destroy his file in this case. The situation just reeks. And that is what our biggest concern is about this, Your Honor. Whether there was grounds for recusal, whether there weren't, whether there was grounds for disqualification, whether there wasn't. What this all boils down to, Your Honor, is a legal question about whether we should allow this to happen. Okay, whether we should allow a defendant in the United States of America to be tried and prosecuted by a mother-son team. I'm going to ask this court to please look at the Supreme Court's decision in Williams versus Pennsylvania. The citation on that case is 136. Supreme Court 1899. And I'm just going to quote, rather than me try to make the argument, I'm just going to tell you what Justice Kennedy said. He said, this court's precedents set forth an objective standard that requires recusal when the likelihood of bias on the part of the judge is too high to be constitutionally tolerable. He goes on to say that bias is easy to attribute to others and difficult to discern in oneself. To establish an enforceable and workable framework, this court's precedents apply an objective standard that, in the usual case, avoids having to determine whether actual bias is present. The court asked not whether a judge harbors an actual subjective bias, but instead whether, as an objective matter, the average judge in his position is likely to be neutral, or whether there is an unconstitutional potential for bias. And this was important in this case, Judge, because in Williams versus Pennsylvania, it was a decision involving whether the prosecutor could later be involved as an appellate judge. And Justice Kennedy noted that no attorney is more integral to the accusatory process than a prosecutor who participates in a major adversary decision. And he went on to say that this context only heightens the need for objective rules, preventing the operation of bias that otherwise might be obscured. Judge, our entire criminal justice system can look back on this and say, this is a shame. This is an abomination to have a situation like this occur. No record, no indication of what was said. And the mere fact that this man who was offered 9 years before trial gets sentenced to 60 years by the mother of the prosecutor just does not create a good appearance. It should not be allowed under the law. It shouldn't be allowed under the precedents. I know that Mr. Holden is going to say, well, there's cases out there that say that the prosecutors are not a party to the litigation. But I think in light of Williams versus Pennsylvania, this court, and I believe that the Court of Criminal Appeals is going to need to take a closer look to ensure that we don't have a situation like this. Texas was a laughingstock for having a sleeping lawyer during a death penalty capital. We don't need to have us continue to be a laughingstock because we had a man sentenced to 60 years.
I'm sorry, hold on 1 minute. I don't know why that rang. I had my phone turned off, so it's just got a mind of its own. Anyway, go ahead. I'm very sorry.
Apology, Your Honor. I'm just simply going to say that, look, this stinks. And that's why Mr. Moore and I agreed to take this matter on pro bono. The whole appearance of this just stinks. It's not right. It's not what our criminal justice system should allow. It's not what the law should allow. It violates his right to due process. We're asking for a chance to give him another trial with impartial jurists that don't have any connection with the state or the prosecution. We're asking for that you grant habeas relief in this case. Thank you, Your Honor.
Before you go, Mr. Holden, I want to ask Mr. Mayor a question about the Williams case. And I'm sorry if you included that in your materials and I missed it.
No.
I want to ask you a question. Of course, that relationship that you described would be prohibited in Texas and would be a disqualification.
That is correct.
And so I guess you're sort of extrapolating that situation to this situation, although that situation would have been forbidden in Texas as a disqualification.
You've hit the legal question nail on the head, Your Honor. I mean, that's a situation that we're faced with. I mean, there is nothing that is squarely said that a situation like this is grounds for disqualification. Well, I'm sorry, there is a precedent on that, but our position is, in light of the Supreme Court's decision in Williams versus Kennedy, if you extrapolate what Justice Kennedy talks about in that case and the importance that the role of the prosecutor has in that case, it unconstitutionally, it doesn't bode well with what our Bill of Rights provide for. I'm asking you to extrapolate what he said into a situation like this. You've hit the nail right on the head.
Well, I'll take a line of yours. I hope it's my last question. How about that?
Oh, you asked as many questions, Your Honor. I've been more than
filling me in on Williams because I had not read that in preparation for this hearing. But I did want to ask you one more question about, you said there is authority in Texas law for Judge Evans to have been disqualified. And I know you cited Ex parte Vivier. That's how people from Louisiana say it. I don't know really how it's supposed to be pronounced, but that's my best take on it. Now, in Vivier, the party was related to the judge, correct?
right.
Okay. And so that's distinct from this situation where a lawyer is related to the judge.
That's correct.
And you're trying to make the jump to Williams, from Williams to that.
I'm saying based on Williams that there needs to be a jump. I don't, Mr. Holden probably does. If not, I'll find it and I'll provide it to the court. But there is a case, there's an old case out of the Texas Court of Criminal Appeals, I believe, where it's not, where the court held it wasn't grounds for disqualification, that the judge was related to the prosecutor in that case, because the reasoning was it was not, the prosecutor is not a party to the litigation. So if Mr. Holden can't cite the court to it, I'll find it and I'll tell you what it is. But that is what the law has been, that's what was previously held years ago by the Court of Criminal Appeals. Our position is that in light of Williams versus Pennsylvania, and because of a greater concern by the Supreme Court of an individual's due process rights, when you have this sort of relationship, we're asking for relief on that grounds, regardless of whether he was advised or whether he was not advised of his opportunity to seek a recusal in this case. One last thing I'll also say, Your Honor, is I think that it's important to note Mr. Cargill's responses in regards to the grounds for the recusal. And what I mean by that is if you find, you may find that Mr. Gross's representation that this was never discussed with him. You believe Mr. Cargill over Mr. Gross. But the problem, Your Honor, is that if you listen to Mr. Gross and his explanation of what he knows about the recusal law, it's not, I think that this judge can be fair or impartial. There's an objective standard that is applied. And so I think you need to take that really strongly into consideration. And if you find that he did talk with Mr. Gross about that, did he adequately advise him about that? Did he explain, look, whether I think she can be fair or not, we're still entitled to this because of the objective standard that is set out under our precedent and under our law, and it was repeated by Justice Kennedy in the Williams case. So I think that's another issue that I want the court to really take note of is Mr. Cargill's testimony and as to what he thought the law was regarding recusal, because I don't believe that his knowledge is sufficient to have been able to properly advise Mr. Gross, if he did in fact advise Mr. Gross, what his options were in terms of a recusal. So I just wanted to throw that out there and make sure that the court was aware that, we picked up on that. And I think that that's an important point, that he did not fully grasp the law on recusal.
All right. Thank you. Mr. Holden?
Your Honor, our first point, I've just looked through the writ again, and I see no citations to the United States Constitution or any other. We're all under Texas law here. So whatever the Supreme Court has just recently said is not an issue. What is an issue is Judge Evans cannot be disqualified in this case because she doesn't meet any of those points of error. She is not related to any party to this case. The party is the state of Texas or the defendant. If she was related to the defendant, she would have to be disqualified. Being related to an attorney is not a disqualification. Just off the top of my head, at a quick search, there is a Lexus case from 2005, and it is a non-reported case, Court of Appeals from the 4th District, where the judge was related to one of the attorneys or a member of that attorney's firm, I think one of the partners, and the court said they're not a party. That is not a disqualification. Gutierrez via Hyatt, all I can give is the Lexus, which is, I would give it, 2006 Texas app, Lexus 1747, or 2006 WL Westlaw 542592.
And what was the name of the case?
It's Gutierrez via Hyatt, Hiatt.
Okay, I saw that case. Thank you.
And so I don't think we ever get to a disqualification. We're only on the situation as to whether or not a recusal was requested. We've heard from Mr. Cargill. He has given not only in his affidavit, but on testimony via direct cross that the relationship was pointed out and that Mr. Gross thought that would be in his favor, that she'd be more fair or be more likely to get probation. Furthermore, Your Honor, they keep wanting to come back to how the appearance of the district attorney prosecuting the case has got total control over this case, Mr. Brian Evans, when the facts are he had little to no control. He had one witness, and the entire time he was standing there with Allison Mitchell, the elected district attorney. And as every prosecutor knows, an assistant, when we're speaking out with the voice of our elected. It is the elected that will matter in this situation, and the elected who controlled, and the elected who made all the decisions in this case. As to any other grounds as to whether or not he had deficient performance, even if they get there, they have yet to show one of the final prongs of the Strickland standard. They have to show that it had an outcome or a bit on this case, that but for any deficiency he had, the case would have turned differently. And there is no evidence of that anywhere in the record. There was no objection that went against Mr. Cargill, no significant one. There's no, they waived any argument as to whether or not he should have put on mitigation evidence. They cannot show that because of Judge Evans and in relationship to Brian Evans, that there was any different outcome in the guilt innocence, particularly as guilt innocence was done by a jury. Then months later, when it's at the punishment phase of the trial, Mr. Evans wasn't even involved. It was Miss Mitchell alone. So they cannot prevail on the fact that they cannot show that, but for any deficiency of Mr. Cargill, if there was any, that there would have been a significant difference in this case. Your Honor, we believe this writ should be denied, and Mr. Gross served the rest of his sentence.
Mr. Holden, I have a question for you. And it's probably a little out of your area, but because I'm going to start talking about civil things. Texas, not because you're otherwise not capable, but you are a prosecutor. You're not.
I'm a prosecutor. I'll admit I've not done civil practice.
All right. The Texas Rules of Civil Procedure 18B discusses the grounds for recusal, disqualification too, but also recusal. And
Sure.
do you think those apply in a criminal case?
I know for a criminal case in a recusal matter that that the attorneys are referred back to the civil rules and how to file them, and I believe also for grounds. So yes, I do believe they apply, and I request of whether there should be a waiver.
And what?
And the rules as they're set out as to whether or not.
I'm sorry, I missed what you said about waiver right at the end.
And that you have to, if there is an issue, you've got to get your client to waive it. As I understand it. I may be misspeaking because again, I'm not a civil attorney and I'm not maybe not.
Well, right, and I qualified my question like that. So thank you for answering it anyway. All right, well, that's all we're going to do on that today. I do want to take a break. Oh, wait a minute. Don't anybody go anywhere. Not that kind of break. Could the court reporter come back on, please? We're going to be very upset if you're not there. Can you unmute yourself?
Her name's Patricia, Your Honor.
Oh, thank you. I couldn't remember your name. Patricia, can you turn on your camera and unmute yourself, please? Thank you very much. Thank you so much. And thank you for supporting this hearing today. You've heard the lawyers say that they have offered exhibits and they're going to deliver those exhibits to you. If we were in the courtroom, where I'm sure we would all have preferred to be, but this is a hearing that we can have remotely. And so under the current standards, we are having it remotely. If we were in the courtroom, I would say nobody leaves this room until the exhibits are delivered to the court reporter. So I think the state, as the respondent, had a couple of exhibits. The applicant had a couple of exhibits. They're going to get you those directly. And you'll need
Yes, and I've been sending them messages.
You're way ahead of me then. Thank you very much. I'm going to ask
Yes.
once they're filed to get me copies of them because I don't have copies of the ones that were admitted today other than the ones that were already attached to the application. The other thing I wanted to mention to you, Patricia, which you probably already know, I'm probably completely preaching to the choir, but 1107 requires you as the court reporter to prepare the record 15 days from the conclusion of the hearing. So just FYI to you, I always mention it because my court reporter used to just about like that. She would have something to say about that. But anyway, she said, you have other things to do. But I'm sure you do have other things to do. But the law requires that you file it with the clerk of the convicting court, which would be the Anderson County District Clerk, within 15 days, if you could do that.
Not Not the appeals court, not the appeals court.
See, I don't know what to tell you about that. It says you have to file it within 15 days with the Anderson, well, with the clerk of the convicting court, which is Anderson County District Clerk. If I were you, I might upload it to the portal
Okay.
on Thames because they also like things done like that. So I don't know what to tell you. The statute says to the Anderson County District Clerk, Thames has its own rules, and I'll leave that to you. Remember, this is not an appeal. It's a writ of habeas corpus. So it's not really governed under the appellate rules. But again, I do what everybody at the appellate courts, whether they're the intermediate appellate courts or the Court of Criminal Appeals and Supreme Court, I do everything they tell me to do. So I'll leave that to you. But I
So
did.
do I.
It says file it at the convicting court's district clerk or clerk. So FYI to you on that.
I'll just make sure Susan follows it both.
Okay,
I
perfect.
appreciate it. Thank you.
You're welcome. And thank you for bringing that up. I meant
Thank
to
you.
mention that too. Before everybody gets out, Ms. Singletary has just shared your email address with us, which I'm sure you're totally fired up about. And I'm going to just say it out loud so that I can write it down before everybody gets off and my screen goes blank and I don't have it anymore.
Judge, we have it. I have it off on the chat. I have it on the chat. And so since we're on live YouTube proceedings, if we don't want to put that out there in the public domain, I'll just tell the court that I do have it off in the chat.
Okay, and I'm sure the State's Counsel can get it off of chat too, but what I'm saying is once we end this hearing, you don't have access to your chat anymore.
Oh, I've already written it down so that I have it.
Well, that takes care of you. Do you have it, Ms. Mitchell and Mr. Holden?
Your Honor, I have it. I'm trying to get the email together to send our 2 exhibits to her right now. I've got her email attached. Also, Your Honor, I forgot, we need to ask that all the evidence be closed.
The evidence is closed. We're finished with this hearing.
Thank you, Your Honor.
All right. Okay. Anything further from the applicant?
Yes, Your Honor, just, and this doesn't need to be on the record, just a discussion. Did you, our deadline was back on the 15th, but did we get a request to the Court of Criminal Appeals extending your deadline, or did you need us to prepare something for you?
I did not, and you don't need to prepare anything. I'm going to go ahead and make the findings of fact and conclusions of law that I proposed to the Court of Criminal Appeals.
And that was going to be my next question, whether you want to propose, but if you don't want any proposed from us, then I guess we'll just wait for a ruling from you.
I think just wait for a ruling from me. I don't think it's going to be terribly long. I've already drafted the legal section of it because I had some time to do that, and you never know what's coming tomorrow. And I was just waiting to hear what the facts were, and I heard that today. So I would think, I do have a little bit of traveling coming up, but I would think no later than the middle of April. That does push us past the date they gave us. But I've not had them before. Now here I am saying on the record, I've not had them before complain about a little bit over. And I say complain, remind me or whatever. I really haven't had that, but it certainly could be the case.
My experience and my knowledge with my discussions with the clerks up there is they're really only concerned about that initial 180 days. They want to see that something's done. Once they grant an extension after 180 days, I've had a lot of times where cases have sort of gone on without anything else. And as they're usually pretty lax on that, is what I can tell you from my experience. So
Well, I don't know about that. I would just say I'm going to do them as rapidly as possible, and I hadn't planned to seek another extension. Let's see.
Your Honor, just the last thing.
Hold on, wait a minute. Go ahead. I had something else on my mind, but go ahead.
Okay, that case that I wanted, that I was telling you about, that old Court of Criminal Appeals case, it's McKnight versus State. Its citation is 432 Southwest 2nd, 69, 1968. I wasn't even born yet. That was a case where the judge, the district attorney in the case was the son-in-law of the judge presiding over the case, and the Court of Criminal Appeals held that he's not a party, so there's no grounds for disqualification. So I told you I would give you that case, and that is what the existing law is. We're just, again, maintaining it's changed in light of more recent precedent. So I think that's it.
Okay, so the last thing I wanted to talk about is the nut-pro-tunc. That was removed from the first application by amendment when you filed the amended application. And I did not finish it because we were starting to talk about it at the hearing where you said you had filed a motion to recuse. So
Right.
I'm working on that. And now I need to get Judge Charles to assign me to the underlying case as the senior judge of the 114th. So I will do that.
Okay.
I'll ask him to do that. And I don't think that's much of an uphill climb, but I already have the judgment prepared. We had talked about it at length, what the problems were in the judgment, and I have it ready to go. I just need to ask Judge Charles for an assignment.
Judge, if I may, because Mr. Gross hasn't been present for all of our proceedings, I don't think he has. Mr. Gross, what the judge is talking about is correcting your judgment to correctly reflect that this was not an aggravated case. That was the only issue, right, David? Yeah. So the judge is basically acknowledging that, and we don't have any issue with her issuing the new judgment that that removes the aggravated element on your judgment and sentence. Okay. You can just, if you could just nod or thumb to let us know that you heard that. Okay. So
Okay.
that's what we're talking about right here. I don't think we had talked about that with you. We've been talking about everything related to the writ. That's what the judge is talking about here. Okay.
And Mr. Gross, that you might be muted, and I don't know if you're able to turn on your sound yourself, but again, I'll ask you in a minute to wave if you understand this. The reason, thank you, your lawyers were concerned about this because if your case is for an aggravated offense, like aggravated assault on a public servant, it changes the parole eligibility, and it's different for an aggravated offense and a non-aggravated offense. And so your parole eligibility, I'm sure you've had an opportunity to discuss with your lawyers, is different and worse for you on an aggravated offense. This was not an aggravated offense. It was not tried as an aggravated offense. And so the judgment is just in error. And I'm going to correct the judgment. I've talked to your lawyers and lawyer about the state for us for that. And as soon as I asked Judge Charles about an assignment, in the underlying case, they have different cause numbers a little bit. So I have to ask for an assignment in that case, and I will correct the judgment, and it will reflect that it's not an aggravated offense, which would mean that the parole eligibility is better for you. So wave your hand if you understand that. All right, thank you very much. I know I have kept everybody from their lunch. Thanks everybody very much. How about don't let the sun go down on today without getting the exhibits to the court reporter. And thank you all very much. Is there anything else before we're in recess from the state?
No, Your Honor.
No,
Mayor.
Nothing from the applicant other than, Judge, if this is the last time we see you, it's been an absolute pleasure. And again, we thank you for all of your time and your consideration on this. And I'd say I'd look forward to appearing before you, but unless it's as a visiting judge, I guess this might be it. So
I know this is it. I've had a good time. It's very interesting to me. Mr. Moore, I remain a little bit disappointed. You're not the other David Moore, but whatever. And I'll try to get you all some findings as soon as possible.
thank you, Judge. Have a good one.
Ladies and gentlemen.
Thank you, Mr. Moore.
Mr. Gross, you too. Thank you.
Mr. Gross, we'll talk to you soon, okay?